international justice. No less than His Excellency President Bongbong Marcos has pledged and guaranteed that human rights would be protected during his term. The CHR, as the National Human Rights Institution of the Republic of the Philippines, and mandated to protect and promote the human rights of every Filipino, we are of the position that that the Commission will cooperate if the ICC so requests, and the extent of our cooperation would be determined in accordance with the specific request of the ICC and within the mandate of the Commission on Human Rights. Thank you very much.
All right, thank you. We have the Center for International Law, Attorney Gilbert Andres, the Executive Director. Will you recognize, please?
Good morning, Mr. Chairs, and good morning, Your Honors. Your Honors, is the position of the Center for International Law that we should cooperate with the ICC, and we urge the approval of the 3 House resolutions on 6 grounds. In fact, Your Honor, I will not start with public international law. I will start with Philippine domestic law, because in fact, this Honorable House, together with the Senate, passed in 2009, RA 9851. What is RA 9851? It's the Philippine Act on Crimes Against International Humanitarian Law, Genocide, and Other Crimes Against Humanity. It was signed into law on December 11, 2009. In fact, Your Honor, what was the context? Why is it that this Honorable House and the Senate passed 9851? Because at that time, we signed the Rome Statute, but we were not a state party to the Rome Statute, because the President did not send the ratified Rome Statute to the Senate. Hence, there was actually an advocacy campaign for the Philippines to satisfy its international obligation under international humanitarian law, under the Geneva Conventions. And we have ratified all of the Geneva Conventions. Hence, Your Honors, your Congress passed RA 9851. And what does RA 9851 provide? Your Honors, I want to refer you to Section 17 of RA 9851, because it actually provides for the reverse complementarity principle. And I will read it, Your Honor, and I want to place it on the record, that relevant portion of Section 17. And I quote, "In the interest of justice, the relevant Philippine authorities may dispense with the investigation or prosecution of a crime punishable under this act if another court or international tribunal is already conducting the investigation or undertaking the prosecution of such crime. Instead, the authorities may surrender or extradite suspected or accused persons in the Philippines to the appropriate international court, if any, or to another state, pursuant to the applicable extradition law and treaties." Hence, Your Honor, what is actually provided in Section 17 of RA 9851 is reverse complementarity. In fact, the Philippine authorities may just opt to just surrender an accused person before an international tribunal, such as the ICC. And Your Honors, in Senator Pangilinan versus Cayetano, the Supreme Court actually referred to this principle of reverse complementarity. How do I know? I was actually, Your Honors, a petitioner and a counsel in that petition, PCICC versus Executive Secretary. Hence, Your Honor, it's actually an exercise of sovereignty for the Philippines to cooperate with the ICC, because it's provided for under Section 17 of RA 9851. Your Honor, our second point is important, especially in the context of the West Philippine Sea dispute. Our Philippine Coast Guard, our Filipino fishermen, they have been harassed by the Coast Guard or by the militia of a certain state in the north, a powerful state. And what have we been invoking always? We have been always invoking international law and compliance with a rule-based international legal order. In fact, Your Honor, the arbitral award that was decided on July 12, 2016, Philippines versus China, it's based on international law, the UN Convention on the Law of the Seas. And it's a historical fact that China does not recognize the jurisdiction of the arbitral body. China does not recognize the arbitral award. And yet it does not invalidate the arbitral award that we have won, and which we have won not just for the Philippines, but for the region in Southeast Asia. Because we say that we should adhere to international law and a rules-based international legal order. Hence, Your Honor, if we be faithful with that consistent plea of the Philippines for international law, we should also be consistent with our international obligation under the ICC Rome Statute, which leads to our third point. Your Honor, the Philippines was actually part of the delegation of plenipotentiaries in the ICC Rome Conference in July of 1998. We actually sent a delegation to actually participate in the drafting. And we were actually very active in the drafting of the ICC Rome Statute. In fact, Your Honor, we signed it in December of 2000, except it was not passed for concurrence by the Senate. And when it was signed, it was actually ratified by the President. It was sent to the Philippine Senate for its concurrence. And in fact, during the deliberations before the subcommittee, then chaired by Senator Miriam Defensor Santiago, agencies of the government actually supported the concurrence of the ratification. What agencies were these? These were the DOJ, the DFA, the Philippine National Police, the Armed Forces of the Philippines, the Commission on Human Rights. They actually approved and supported concurrence into the ICC Rome Statute. And Your Honor, on August 23, 2011, the Philippine Senate, on a vote of 17-1, passed, concurred into the ICC Rome Statute. And you can see from the records who were one of the 17 senators. It was then Senator Ferdinand Romualdez Marcos Jr. Yes, he voted for the approval, the concurrence of the Rome Statute ratification. And Your Honor, it's presumed that legislators actually do their official business in good faith, that you have read all the drafts, all the bills, all the resolutions that you are actually voting upon. And Your Honor, in fact, if we were a state party to the ICC, it means that we are obligated under the ICC. And in fact, there's actually a residual obligation, even though we withdrew. It's in Article 127 of the ICC Rome Statute. And I want to refer Your Honors to Article 127. In fact, it's an important article because it's precisely the article that the Philippines invoke in order to withdraw. That's paragraph 1. But in paragraph 2 of Article 127, it provides for a residual obligation. And I want to quote that verbatim in paragraph 2. And I quote, "A state shall not be discharged by reason of its withdrawal from the obligations arising from the statute, while it was a party to the statute, including any financial obligations which may have accrued. Its withdrawal shall not affect any cooperation with the court in connection with criminal investigation and proceedings in relation to which the withdrawing state had a duty to cooperate and which were commenced prior to the date on which the withdrawal became effective. Nor shall it prejudice in any way the continued consideration of any matter which was already under consideration by the court prior to the date on which the withdrawal became effective." And Your Honor, again, in Pangilinan versus Cayetano, the Supreme Court referred to Article 127 of the ICC Rome Statute, and even it actually affirmed our residual obligation under that provision. In fact, it says that we really have to cooperate based on Article 127, paragraph 2 of the ICC Rome Statute. Which leads, Your Honor, to my fourth point. Your Honor, complementarity has always been said to be a provision wherein the ICC will come in if the state is unwilling or unable. Your Honor, to be honest and to be frank, with all due respect, that's actually a misconception. Why? Because if you want to look at complementarity as a principle, you have to look at Article 17 of the ICC Rome Statute. And Article 17 of the ICC Rome Statute has 3 paragraphs. 1, 2, 3. This is the architecture. Paragraph 1 refers to any situation, any cases that are not admissible before the ICC. And what are these cases which are not admissible to the ICC? These are cases wherein an investigation or a prosecution has been done, okay, except the state is unwilling or unable to genuinely prosecute or investigate. Meaning to say, Your Honor, if you just look at the grammar, the text itself, it presupposes that there's an investigation or a prosecution for international crimes. Now, if there's an investigation or prosecution, then the ICC will look, is this investigation or prosecution, is it really genuine? Or the state is unwilling or unable to genuinely, and I'm saying that, genuinely, to emphasize, investigate or prosecute. Hence, Your Honors, it means that if the state is not actually investigating or prosecuting, then that's the time that the court, the ICC, will do its complementary jurisdiction. Why? Because the state did not do its primary jurisdiction to investigate international crimes. And the context here, Your Honors, these are not just simple crimes. These are most serious crimes of concern to the international community. In fact, these are international crimes, war crimes, genocide, crimes against humanity. And we had that experience, Your Honors, during the Japanese occupation. 100,000 Filipinos were murdered, looted, raped, burned in Manila from Feb 3 of 1945 up to March 3 of 1945. 100,000 Filipinos. And that's a war crime. In fact, there was a prosecution, Yamashita versus Tyre. That's a prosecution for war crimes. Hence, Your Honor, that's the reason why if the state is not doing its primary duty to investigate international crimes, then the ICC will come in order to prevent impunity. That's why the question is just simple. Has there been investigations or prosecutions for crimes against humanity, which is actually a crime under RA 9851, I think Section 7. Has there been actual investigations on crimes against humanity that occurred on the Philippine territory from November 1, 2011 up to March 16, 2019? And you can determine that for yourselves. The resounding answer is none. Therefore, Your Honor, the ICC is not a supranational, it's not a supranational court. It's not a world justice system that will look whether or not you're unwilling or unable, Your Honor. Last, Your Honor. In fact, Your Honor, even non-state parties can actually recognize the ICC's jurisdiction. That's under Article 12, Paragraph 3 of the ICC Rome Statute. In fact, Ukraine, it's not a state party, and yet it referred its situation to the ICC. Hence, there was an arrest warrant for Vladimir Putin. Lastly, Your Honor, the Philippines has been at the forefront of the international justice system. In fact, Your Honor, the Philippines actually contributed to international criminal law in Yamashita versus Tyre, the doctrine of command responsibility. That's because of Philippine jurisprudence. And Your Honors, there's actually a very famous concurring and dissenting opinion by Justice Gregorio Perfecto, and I want to read it on the records. He said that in the violation of the law of nations, the offended party is the people of the whole world, and the case against petitioner could be properly entitled as Humanity versus Tomoyuki Yamashita. And no person in position to prosecute the violators can honestly shirk the responsibility of relentlessly prosecuting them, lest he be branded with the stigma of complicity. Your Honors, our appeal is to also look at it from the viewpoint of the victims. Mga balo po, mga anak, mga kapatid, mga ina, mga ama. na nawalan po ng kanilang mga mahal sa buhay dahil po sa EJK, sa war on drugs. All they're asking is justice. And since it's a fact they did not get justice from the previous administrations, they're asking it from the ICC. And we hope that this August body will really ask the Philippines to cooperate with the ICC for the sake of justice. Maraming salamat po.
Thank you, Attorney Andres. Now I'd like to call former Congressman Attorney Nery Javier Colmenares, please, for his.
Thank you. Thank you, Honorable Chair Amante and Honorable Chair Flores. Maraming salamat po sa invitasyon. I have some slides, Mr. Chair, if I may present it para naman mabilis na masabi. And in fact, in that slides which I did for the previous hearing sana, nakalagay naman doon yung mga ilang points. So first, I'd like to thank our colleagues, my former colleagues, and the House for continuing to invite me in many committee hearings here. And I'm glad that you always wanted to balance your views by inviting two sides to the coin, no? So I think this is just 5 to 6 slides, but can I go to the first slide, Mr. Chair, to explain my position here? Just a bit of a timeline, Mr. Chair. Since 1996, the Philippines under President Ramos took an active role in the ICC's establishment and was even a member of the drafting committee, which is what Gilbert just said. So we did not only sign the Rome Statute, we helped draft it, Mr. Chair. Kaya later on, yung claims to sovereignty, parang nagsintonado siya, Mr. Chair, kasi we helped draft the Rome Statute. December 28, 2001, it was signed or ratified by President Estrada. And August 30, 2011, with the support of President Aquino, the Senate concurred in the ratification. 3 presidents, Mr. Chair, from different political parties, President Ramos of Lakas, President Estrada of Partido ng Masang Pilipino, President Aquino of Liberal Party, all supported the Rome Statute. It is not something personal. It is not about any person in a sense, because all political parties supported it, and it was really supported by the Philippine government. On April 24, Mr. Chair, 2017, Attorney Jude Sabio files a case called communication. They call it communication before the ICC for mass murder. And of course, Senator Trillanes in 2017 filed a supplement there. Notice it was filed before the Philippine withdrew. On August 18, 2018, Rise Up for Life and AJK victims, and disclosure, Mr. Chair, I'm one of the counsels of the families of EJK victims. We filed that case in August of 2018. And mainly, of course, those complaints mainly centered on a former President Duterte. That's why we keep on asking, is he being prosecuted? Because that is in relation to what Attorney Gilbert just said. Precisely, that was a question of the victims of the family. On March 17, 2019, the Philippines withdrew. So, before the Philippines withdrew, was there a matter under consideration by the ICC? The answer is yes. It was already filed before that. It's a matter under consideration. And if you look at Article 127 later on, we will find out what our interpretation is. Next slide, please. So, next slide, please. So, on November 23, 2021, the Office of the Prosecutor defers investigation, giving the Philippines 30 days. That was the request of the Philippines, 30 days, up to December 22. On December 22, the Philippines again sought for a 3-month extension, more or less up to March. The prosecutor granted the request again. And when did the ICC start the pretrial chamber authorize the prosecution? It was in 2023, Mr. Chair. Ibig sabihin, mula 2021, 22, 23, binigyan ng ICC ang Pilipinas ng extension in a sense. Sige, sabihin nyo, iniimbestiga nyo ba? Pinoprosecute nyo ba? Hindi ito parang inapakan ng ICC ang Pilipinas. So, on 26 January of 2023, after appeals by the Philippines, the pretrial chamber authorized the prosecution to resume investigation. Mahaba na po ang nangyari. 2017 pa na file, 2018 na file, 2023 lang. But that's because
the ICC recognized the due process rights of the Philippine government. Gusto niyo mag-imbestiga? Sige, imbestiga kayo. We'll give you chance. Gusto niyo mag-prosecute? Sige, prosecute kayo. We'll give you the chance. But in 2023, sabi ng ICC, tama na. Haba na nito eh. So, on July 18 of 2023, the ICC Appeals Chamber allows the prosecutor to continue the investigation. So, yun ang timeline. Next slide, please. Ngayon, ang binabanggit na complementarity provision, which the government before always raised. Ano ba ang 17? Ang sabi ng 17, ang court inadmissible ang isang kaso against a certain person, for example, if the case is being investigated or prosecuted by a state which has jurisdiction over it. So, ang tanong na naman ng mga biktima, kung tingnan nyo yan, Mr. Chair, yun ang crucial sentence. Yung unless the state is unwilling or unable to carry out the investigation or prosecution will only be triggered if there is prosecution. If there is no prosecution, it is not even an issue for the ICC. Sabihin ng ICC, sabihin ng Philippine, willing naman kami, yeah, okay, you're willing, you're able, your justice system is functioning, but are you prosecuting him? No, o di tapos. Ano ba usapan natin? You're not prosecuting him. So why do you even, able naman kami, yeah, sige lang, but if you're not prosecuting him, may jurisdiction ng ICC. It's a two-stage formula, Mr. Chair. And the willingness and an inability only becomes an issue if the state is prosecuting. Kasi pag pinoprosecute mo at sabihin ng mga biktima, actually, kunyari lang yan, hindi naman yan hindi genuine. As Attorney Andres said, hindi naman genuine. Doon na lang, in defense naman ng kabila, no, it's genuine, we're willing, we're able. Doon na lang yung pag-usapan. But as long as you're not prosecuting or investigating that person, there is even no need to talk about your willingness. Because you may be able, but you're not investigating or prosecuting. So, next slide please, Mr. Chair. I think I'm just 3 slides. Ano ang definition? Sige na, pumunta na tayo sa unwillingness. Kung gusto nating pag-usapan, although sinasabi ko it's not even an issue. Anong definition ng Article 17, Section 2? Unwillingness is the proceedings are being undertaken was made for the purpose of shielding the person concerned from criminal responsibility. Ibig sabihin, yung prosecution, actually intention, kunya-kunyari lang, but actually to shield the person. In that case, kahit pinoprosecute nyo, ang sabihin ng ICC, hindi, may jurisdiction kami. You're actually trying to shield him. Ganon. Or look at letter B, subparagraph B, Mr. Chair. There has been an unjustified delay in the proceedings. Hindi ba delay yun? 2017, 2018 pa na file, 2023 na wala pang kaso. So that actually already shows your unwillingness under the definition of the Rome Statute, which we helped draft. We helped draft that provision. So we cannot now say, hindi, we didn't intend that kasi you helped draft it. Sinabi mo, the moment you're committing unjustified delay in the proceedings, you're unwilling. We agreed to that. So, or the proceedings were not conducted independently or impartially. So I don't see any debate at all on Article 17 on complementarity, Mr. Chair. Kasi ang tanong lang naman, ito prosecute nyo ba yung tao? Hindi, di tapos ang usapan, di ba? Last 2 slides, I think, Mr. Chair. Next slide, please. So, why does ICC have jurisdiction over the case in 2017-2018? Well, tingin namin, because it was President Duterte was the main, kumbaga, accused or respondent then, so, tingin namin is not being prosecuted. So, the ICC has jurisdiction. That's it. And then, of course, unwillingness. Yun lang naman na hinihingi ng mga ng pamilya ng biktima, Mr. Chair. In fact, nagpumunta sila sa amin noong panahong yon. Sabi na, Attorney, pwede ba kami mag-file dito? Sabi ko, pag nag-file kayo dito against him, madidismiss ng korte yan. Bakit? He will claim presidential immunity. So, unable. Di ba? Talaga, o di, saan kami mag-file? Sa ICC na lang muna tayo. Di ba? Kaya nasasaktan ako pag binibira ang pamilya ng biktima at sinasabing, ba't doon kayo pumunta? Ba't doon kayo dumulog? Dapat dito, papadismiss mo yung kaso pag dito final kasi immune ka from suit. That's really, for me, unacceptable na naghanap na nga ng paraan ng hustisya ang mga pamilya ng biktima, tapos durug-durugin mo pa na parang, di ba? That's my opinion, Mr. Chair. Next slide, please. Now we go to Article 127. Ano ba yung pinag-usapan dito? Klaro, Mr. Chair, if you look at that. The state shall not be discharged by reason of its withdrawal from the obligations arising from this statute. Okay na yan. Criminal investigations, its withdrawal shall not affect any cooperation with the court in 1. Criminal investigations and proceedings which were commenced prior to the date on which the withdrawal became effective. So when was the criminal investigation or proceedings commenced? We argue, Mr. Chair, as early as 2017 and 2018, it was commenced. That's why the government cannot now claim na, actually, nag-commence lang yun noong 2021, long after we withdrew. No, it has commenced as early as that. When we filed it, and a preliminary examination has been conducted by the prosecutor. Of course, government kasi, preliminary examination, hindi naman proceeding siya. We can debate that. But the ICC has ruled na bahagi yan ng proceedings. Second, nor shall it prejudice the continued consideration of any matter which was already under consideration by the court prior to the date on which the withdrawal became effective. Question: when did the Philippines withdraw? 2019, March, Mr. Chair. Kailan ang matter when did a matter become under consideration by the court? 2017. It was filed by Attorney Sabio in 2017. 2018, Rise Up for Life and families of the EJK victims filed it in 2018. Was it a matter under consideration by the court? Yes. You filed a complaint, kino-consider, nagpe-preliminary examination ng prosecutor. So it was under consideration by the court prior to the date. Is there an issue of sovereignty on the issue of 127 and even admissibility? No, Mr. Chair. It's not an issue of sovereignty kasi we signed a treaty obligation. For every treaty obligation, you are admitting, sige, UN, magbabayad kami because we signed the charter. Sige, magbabayad kami dyan. Member kami ng kung anong international body. Yeah, in a sense, di ba? But you agreed to that. Ganon talaga yun eh. You lessen a bit of your sovereignty when you involve yourself in an international treaty. Parang kontrata yan eh. Ito gagawin ko para sa'yo. Hindi ka pwedeng later on magsabi na, ay hindi ko gagawin yan kasi it impinges on my agency, on my autonomy, on my sovereignty. Pumirma ka eh. How would we look like if we sign a treaty obligation tapos later on, ayaw namin sundon kasi it tramples on our sovereignty. Sabi ko nga, the one person who cannot claim sovereignty is the person who allowed China all the claims in our territorial claims in the West Philippine Sea. So in the end, I think I have the last slide, Mr. Chair. Just the Supreme Court decision that was already raised by Attorney Gilbert. I will not go into that, but the court said very clear, withdrawing from the Rome Statute does not discharge a state party from the obligation it has incurred as a member. Last point, Mr. Chair. This is not something personal. And I remember the quote of Honorable Abante. This is not personal. This is about justice. Allowing families of the victims to at least naman makakita ng konting aninag ng hustisya. That they were so deprived, their due process rights were so trampled upon for so many years, Mr. Justice, they have to go to the ICC at the time to ask for justice. So in the end, it is about abiding by our international obligations. It is about abiding by international law. It is about justice to the victims. Hindi ito personal. This is about the dignity and rights of a sovereign people to assert its rights against tyranny, its rights against crimes against humanity, and its rights against heinous violation of people's rights. Maraming salamat, Mr. Chair. Thank you.
Thank you, Tony Neri. Let me remind our straw speakers that we are very lenient with your time. So we are just allowing 5 minutes of your time to speak, but we're very lenient because we'd like to hear exhaustively all your explanations.
Thank you, Mr. Chair, for
Anyway.
the leniency. I appreciate that.
Yes, now I'd like to call Attorney Michael Tiu of the University of the Philippines College of Law, please.
Thank you, Mr. Chair. Thank you to the honorable chairpersons and to the honorable members of the committee for the invitation. I speak in my capacity as assistant professor of the UP College of Law, working on international criminal law, and also as a member of the International Institute of International Legal Studies of the UP Law Center. I begin with, Mr. Chair, I will not repeat any more the points raised by our colleagues on the applicability of some of the provisions of the Rome Statute. But I begin with the provision that I think is most relevant to the resolution, which really urges the state, the executive in particular, and agencies under it to cooperate with the Office of the Prosecutor of the ICC. For me, the relevant provisions would be Article 87 of the Rome Statute. 86, Mr. Chair and members of the committee, speaks of the obligation to cooperate, which I agree is not triggered at this point because it only refers to states parties. So at this point, because we are no longer a party to the ICC, 86 will not be applicable. 87, however, is applicable because it speaks of our voluntary cooperation to the ICC. On that note, that cooperation will not arise, or that opportunity will not arise if there is no request for cooperation. But it does not bar the Philippines, the state, from expressing its sense that it is willing to cooperate under that provision. Now, the question, Mr. Chair and members of the committee, so let me just enumerate Article 87, which speaks of the cooperation, the request for cooperation to a state who is not a member of the Rome Statute can be had through different means. It is quite flexible. The first one is ad hoc, so it can be for this particular instance only and in whatever form would be agreed between the parties. The second one is through an agreement, which I think would be more permanent depending on the temporal or the time element of that agreement. And the third is a catch-all mechanism in which the cooperation can be had in any appropriate means that the Philippine state will deem proper. So in that case, in my opinion, it does not waive the contentions on jurisdiction. There is also no question about whether there is intrusion into sovereignty, because the decision to cooperate voluntarily with the International Criminal Court is an exercise of sovereignty. So if the Philippines does decide to cooperate voluntarily, there would be no problem because it is an effort or an initiative that comes from the Philippines. Now, the question, and I would refer back to the question of the decision or the characterization of the decision as a political one, and I agree. And on that note, I don't think that an exercise of a political decision like this, because you will hear members of the committee a contention that it intrudes upon the prerogatives of the executive, particularly because the president is the foreign policy architect, and therefore it is as the sole prerogative of the executive to decide on this matter. And of course, the bedrock principle there would be separation of powers, as we all know. I think, and this honorable body is well aware because of the work that it does every day, that the separation of powers is not a straitjacketed principle. It allows for the dynamic interaction of the departments. And in this case, that dynamic interaction would be present because the resolution will only urge the executive to cooperate. It does not compel the executive to cooperate, but it does express the sense of a co-equal branch of government, and both of them are political departments in our system of government. So I would say that that dynamic relationship is an important illustration of how the departments should work with each other. I would even go further to opine, Mr. Chair, that and members of the committee that this is an opportunity to exhibit that dynamic operation of separation of powers and corollarily checks and balances, because the legislature, in particular the Senate, had little to no participation in our withdrawal from the Rome Statute. That was decided by the executive, and while there may have been resolutions filed, as this is noted in the Pangilinan case as well, to objecting to the withdrawal without the concurrence of the Senate, that had not been considered by the body. And so I think that this is an opportune time to discuss this, to have this dynamic relationship play out. So on that point, Mr. Chair, so that's the point on jurisdiction and waiver of jurisdiction. Another point, Mr. Chair, is our cooperation an indictment of Philippine or domestic institutions? I don't think so, Mr. Chair. My opinion is that at this level, where it's just an investigation, there would be no indictment of those institutions. So what would happen at most is that those investigations will proceed simultaneously. Cooperation, honorable members of the committee, will not bar domestic investigations. All the investigations will still proceed. But why is there a need to cooperate? Because in both cases, whether we're talking about ICC investigation or OTP rather investigation or domestic ones, time is of the essence because evidence erodes. So here, we are not only talking about delay in the sense of injustice to the potential defendants or accused, but we're talking about delay that affects what evidence can be used. So if we wait so long a time to investigate, then all your forensic evidence will no longer be there after a period of time. And that goes into, as discussed earlier, questions of admissibility and whether that evidence in the first place is being used by national investigations. I also want to emphasize, Mr. Chair, that the purpose of an investigation, or at least the one that is conducted by the OTP, is to find facts. So there is no person identified yet. That's precisely the point. We are trying to identify. In the past, the Office of the Prosecutor pursues a case against the person most responsible for the offense. And so we don't know that yet. That is precisely the purpose of the investigation. And I think that this honorable body, alongside other agencies, is in the best position to understand what an investigation could flesh out, because in the course of the work of the honorable members, especially in legislative investigation, that's exactly the point. We're trying to find out what happened, and the outcome is not predetermined. And that is also the case here. It could turn out that the OTP investigation finds that there's no crime or that no one is responsible, or we cannot pinpoint who is responsible. So I think that that process should be allowed to play out, as it doesn't anyway infringe upon our jurisdiction. And why do I say that, Mr. Chair? Because again, of Article 1272, which had been explained earlier, but also because when we signed the Rome Statute, we accepted that entire regime. We accepted in our signing that even though we could withdraw from the Rome Statute, there are residual obligations. And on that point, I want to respond to two particular points. The first one is there is no residual obligation because this matter that had the preliminary examination that is being conducted by the OTP is not a matter before the court. My opinion there, Mr. And the contention is that because it's only before the Office of the Prosecutor, which is as in domestic parlance is part of the executive, not part of the judicial process, it is not a matter before the court. But I would refer the Honorable Committee to Article 34 of the Rome Statute, which mentions or enumerates the organs of the court. It mentions the Office of the Prosecutor along with the registry as organs of the court. And one other clue, Mr. Chair and members of the committee, why I think that the OTP is part of the court as it is envisaged in the Rome Statute is that unlike domestic jurisdictions where prosecutors have a free hand to file cases, file information in our domestic language, here they have to ask for authority from the pretrial chamber. And so the relationship is intertwined. between the OTP and the pretrial chamber. So, and then the last point, Mr. Chair, which is my end point in this discussion, before I open myself to questions, is that the Rome Statute, its entire architecture, and the point is really to prosecute the crimes of most serious crimes of international concern. That's why the international community has an interest. But also, Mr. Chair, so that there is no impunity. So the design of 1272 is that even that you cannot defeat the powers of the court, the jurisdiction of the court, by simply withdrawing from its regime when the processes are no longer going for you. And so if in this case the investigation or the court does not recognize its jurisdiction, there is an implication in its very purpose, which is that there is no impunity in the commission of crimes, as in this case, crimes against humanity. Thank you, Mr. Chair and members of the committee.
Thank you, Attorney Tio. Now, we'll call on the Rise Up for Life and Rights. I think they have families of victims here. Go ahead. Recognize.
Maraming salamat po. Ako po si Ami Jane. Ang aking asawa ay si Michael na napaslang noong March 2017. At kinakatawan ko po ang mga pamilya ng biktima. Bahagi po ito ng Rise Up for Life and for Rights. At ito po ay network ng mga taong simbahan at pamilya ng biktima ng war on drugs. Kami na mga pamilya ng biktima ng war on drugs ay unang-una nagpapasalamat sa mga kinatawan ng Kongreso na nagsagawa ng resolusyon na makipagtulungan ang gobyerno ng Pilipinas sa ginagawang investigasyon ng International Criminal Court kaugnay ng crimes against humanity na naganap sa panahon ng dating Pangulong Duterte sa kanyang kampanyang Oplan Tokhang. Naniniwala at umaasa kami na ang investigasyon na ito ng ICC ay para sa interes ng mga maralitang pamilyang nawalan ng mga mahal sa buhay na sa nakaraang 7 taon ay patuloy na naghahanap ng hustisya. Mahalaga sa amin ang resolusyong ito upang magbigay ng daan na mapanagot ang pinakaresponsable sa mga naganap na pamamaslang sa halos 7,000 biktima ayon na din sa datos ng gobyerno. Sila ay aming mga anak, kapatid, asawa at magulang. Ang pagsasampa ng kaso sa lokal na korte sa ating bayan ay lubhang napakahirap sa aming mga pamilyang namatayan. Kami ay mula sa mga maralitang pamilya na walang sapat na sweldo at kabuhayan. Karamihan sa amin ay pedicab driver, labandera, construction workers, nangangalakal, street vendors at street sweepers. Dahil sa ganitong kalagayan, ang magkaso o maghabla ng mga salarin na kadalasan ay mga kapulisan ay hindi nagaganap. Ang kawalan ng pera para makapaghabla at takot sa pagkuha ng mga dokumentong kailangan at walang testigo sa naganap na patayan ang ilang kinakaharap naming mga pamilya ng biktima. Dahil dito, kaming mga pamilya ng biktima ay naniniwalang mahalaga ang investigasyon ng ICC upang mapanagot, pangunahin si dating Pangulong Duterte at ang mga naging tagapagpatupad ng Oplan Tokhang upang makamit ang hustisya, matigil na ang pamamaslang at maibsan ang sakit ng kalooban ng mga kaanak ng biktima ng war on drug. Patuloy po kaming magsasalita, patuloy po kaming maghahanap ng pamamaraan upang aming maipahayag ang aming panawagan para sa hustisya. Yun lamang po at maraming salamat.
All right. Salamat, Miss Jane Lee. Now we like to call Miss Emily Soriano, please. You recognize? Andiyan po ba siya?
Isa lang po ang aming sasabihin, yun lang din po, Mr. Chair.
All right. So let me now call the Philippine National Police, Police Brigadier General Rodolfo Castil, Directorate for Investigation and Detective Management. You recognize the General.
To the honorable members of the House of Representatives, Committee on Justice and Committee on Human Rights, especially to its respective honorable chairperson, Honorable Jonathan Kate Flores, sir, and the Honorable Benvenido Abandi Jr., sir, and to all the attendees present in this inquiry, House inquiry. Magandang umaga po sa ating lahat. I am Police Brigadier General Rodolfo Castil Jr., the Deputy Director of the PNP Directorate for Investigation and Detective Management. And on behalf of our Chief PNP, Police General Benjamin C. Acorda, allow me to extend our gratitude to the Honorable Committee for inviting us in this hearing. Upon perusal of House Resolution numbers 1393, 1477, and 1482, concerned government departments and agencies are being urged to cooperate with the investigation of the International Criminal Court on the death that transpired during the anti-illegal drugs campaign of the previous administration. Relatedly, the PNP remains steadfast with its uncompromising stand to observe the rule of law, to respect human rights, and to ensure accountability of those perpetrators of crimes. As to the giving of support to the investigation being conducted by the International Criminal Court, we are of the humble view that it will be more prudent if the PNP will just submit to the position of the President as head of the executive department to which the PNP is under, and of the Department of Interior and Local Government being an agency under the same. That would be all, sirs, ma'am. Magandang tanghali po ulit sa atin.
Thank you, General Co-Chair.
Thank you, PNP. We will now be opening the for questioning of our members. And for those who would like to give questions to our research persons, can you please just inform the ComSec that you would like to do so that we can do it orderly. We would like to recognize first. I'm sorry, go ahead.
May I
Sure.
ask the first question here for
Go ahead.
Congressman Lagman? I just would like to refer the question to a good friend of mine, Attorney Guevara. All right, because you made mention that the withdrawal to the ICC is a political decision. So I just would like to also be enlightened, no, being a non-lawyer, okay? Because a declaration of principles and state policies under the Constitution, where the Philippines adopts the generally accepted principles of international law as part of the law of the land and adheres to the policy of peace, equality, justice, freedom, cooperation, and amity with all nations. Is that also a political declaration?
I think so, Your Honor, because it's a declaration of policy.
Well, to me, that would be more questionable, Attorney Guevara. No, what I'm saying is, when it comes to the Constitution, it is not just a political declaration. It is the Constitution.
Yes, Your Honor.
Now, I'm not a lawyer, but I understand it. You know, that is not a political declaration. It is the Constitution we are talking about. But you were referring to the withdrawal to the ICC as a political question or decision in my.
Your Honor, let me just clarify what I said. I was referring to the matter of extending cooperation to the ICC. That is what I said, na political in character, whether we will cooperate or not. So that's basically, well, as I said, a political decision. That's why I had to explain from my end the legal position, because the legal position will have a very significant bearing on the matter of making a political decision.
Well, since it was a Senate who ratified our membership for the ICC, would it be also the concurrent with Senate whenever the president withdraws from the ICC? Should there be a concurrence of the Senate?
It's an unresolved issue, Your Honor. Kasi yun pong concurrence na binigay ng Senate dito po sa ating pag-join sa Rome Statute or the ICC did not contain any such condition na kung sakali na mag-withdraw ang Republic through the executive department, through the president, ay kakailanganin din po ng concurrence ng Senate. Pwede nyo pong gawin yon as a matter of fact. The Senate can do it if it wants to, na kung magbibigay sila ng concurrence, yung kanila pong resolution granting the concurrence may include, if they wish, a condition na kung magwi-withdraw sa treaty or whatever agreement, ay kakailanganin din ng concurrence of the Senate. But in this particular case po of the Senate concurrence on the ratification of the Rome Statute, wala pong ganong klaseng condition. Kaya po the President had that discretion to withdraw even without the concurrence of the Senate.
Before I recognize Congressman Lagman, just to follow up on the question of my co-chair, Abante. Again, for the Solicitor General. Sir, you said that it is a political question. So my question is, if the House approves the 3 resolutions and the Senate approves its similar resolution, will the government agencies like your office and the DOJ still wait for the decision of the President, regardless of the resolutions passed by the House and the Senate?
Certainly, Your Honor, because your resolutions urge the President to cooperate. So the final say of whether in fact the government will cooperate will be with the President. Yours is an expression of sentiment. That is how you feel about it. But that is not something that is binding. It all depends on the final decision of the President, whether he will grant your request that we cooperate. Nasa kanya po yun. And he has repeatedly declared, ito nga po yung sinabi ko earlier, na we cannot give our cooperation to the ICC prosecutor. Nasabi niya na po yun several times. Now, if he will think twice because of these resolutions coming from the Congress, siya po ang magde-decide nun.
Thank you, Sergeant Guevara. I would now recognize Representative Edson Lagman.
Thank you, joint chairpersons. I would direct my questions to the good Solicitor General, who used to be the Secretary of Justice of former President Rodrigo Duterte. In your presentation, Solicitor General, you delineated jurisdiction into 2 aspects. 1, over the offense, and 2, exercise of jurisdiction. Is that correct?
That is correct, Your Honor.
Now, with respect to jurisdiction over the offense, you conceded that the ICC has jurisdiction over the offense alleged in the complaint filed before the ICC. Is that correct?
Yes, Your Honor. During the period when the Philippines was still a member. So that's from 2011 up to 2019 when our withdrawal became effective.
But it is admitted that the cases were filed during that span of period when the Philippines was still a state party to the Rome Statute. Is that correct?
I wouldn't say cases were filed. Complaints were filed. Yes.
A complaint or a case is similar. I'm just trying to make it understandable to the layman that a complaint is a case.
Not exactly, Your Honor, but we admit na meron pong mga certain groups na nag-file ng complaints before the ICC, but the government did not come to know about these complaints. We were never notified about the existence of these complaints when they were filed.
But subsequently, the government was aware of these complaints.
Yes, when the ICC prosecutor announced that an inquiry was being conducted by the prosecutor.
And when was that announced?
I think that was in 2018 when the ICC prosecutor announced that there was a reasonable basis to proceed.
Mhm. And that was before the effectivity of the withdrawal of the Philippines from the Rome
That is
Statute.
correct, Your Honor.
Okay.
Mhm.
So that is nothing much to debate on. The government, through the Solicitor General, admits the jurisdiction of the ICC over the covered cases. Now, let me go to the next aspect of the jurisdiction as you have delineated, and it is the exercise of jurisdiction.
Yes, Your Honor.
And you said that the exercise of jurisdiction of the ICC lapsed because of delay in the prosecution made by the ICC. Is that correct?
Yes, Your Honor, because the request for authorization to commence an investigation was filed by the ICC prosecutor in May of 2021. He requested authorization to commence investigation.
But prior to that, there was already an examination being made.
Well,
As you
inquiries,
have said,
yes, Your Honor, inquiries being conducted by the prosecutor from all possible sources, open sources, media, newspaper reports. The government had nothing to do with it, Your Honor.
okay. Is there any rule or article in the Rome Statute which provides the time frame within which the ICC or its prosecutors should commence its investigation and exercise of jurisdiction?
There is none,
There is none.
Your Honor.
There
There
is
is none.
There is none. So it appears that the allegation of the government that the ICC jurisdiction has lapsed has no leg to stand on in the Rome Statute.
That is not correct, Your Honor, because I am talking about exercise of jurisdiction. When is that triggered? And it is triggered according to Article 13 when the ICC prosecutor initiates an investigation.
Okay. And what kind of investigation should that be?
That is precisely the subject of his request with the pretrial chamber to commence an investigation.
Is that the preliminary examination or the preliminary
We
investigation?
interpret that, Your Honor, to mean the preliminary investigation.
So prior to that, there was already a preliminary examination and exercise of the jurisdiction of the ICC and its prosecutors. Now, don't you think it is an exercise in futility of admitting that there is jurisdiction over the offense and there can be no more exercise of jurisdiction because it has lapsed?
No, Your Honor, there is no inconsistency between that. As I explained earlier, the Rome Statute tries to balance certain considerations. One is the sovereign right of the state to withdraw if for some significant or important reasons, the state wants to withdraw. That is a sovereign right.
Okay.
And the other interest that needs to be balanced is the ICC's effort to end all impunity. So that is why meron nga pong 1-year period na provided under the ICC.
We will go to that 1-year
Yes,
period.
opo.
I would submit joint chairpersons that it is truly an exercise in futility that you adopt jurisdiction over the offense and you frustrate the exercise of jurisdiction because it has lapsed, particularly so when there is no rule in the Rome Statute with respect to the time frame within which the ICC or its prosecutors should act. Now, may we know whether the state party to the ICC, like the Philippines, would have concurrent obligations as well as residual obligations?
Ang tinatanong niyo po ay ang ICC Or ang member state po ba ang tinatanong niyo?
Yung member state, the member state of the Rome Statute, which created the ICC, does the member state like the Philippines have concurrent obligation when it is still a member, or when it is still a state party, and has residual obligations after its withdrawal becomes effective.
Yes, Your Honor, definitely. Habang siya ay miyembro ng ICC, naturalmente lamang po na meron siya mga certain obligations to perform as a state party to the Rome Statute. At meron din po siyang residual na obligations like halimbawa po yung mga contributions, mga financial contributions. Kahit na po siya ay nakapag-withdraw na, kung meron pa po siyang mga financial obligations, ay patuloy pa po niyang kailangang i-discharge yung ganong klaseng obligation, which is residual after the effectivity of its withdrawal.
Maliban sa financial obligations, meron pa ba na residual obligation ang isang state party na nag-withdraw na with effectivity?
Maring mayroon pa po yung sinasabi nga na residual obligation to cooperate. Opo, pero yun pong obligation na yun ay hindi na magmamatter kung talagang effective na po ang kanyang withdrawal.
Ang gusto mo, hindi na residual yun kung effective na yung withdrawal. Ang residual ay after the effectivity of the withdrawal. Ang sabi mo ay merong residual obligation with respect to financial obligations.
Yes.
Meron ba bang ibang obligasyon?
Kung ang tinutukoy niyo po yung after the effectivity of the withdrawal, ay wala na pong legal duty
Wala
to
na.
cooperate.
Wala na. Nabasa ba po ninyo? Palagay ko, nabasa naman ninyo yung
Article 127. Your
Article
Honor.
127.
Yes, sir.
Ano sinasabi dito? Let me quote again. This was quoted previously. A state shall not be discharged by reason of its withdrawal from the obligations arising from this statute while it was a party to the statute, including any financial obligations which may have accrued. Its withdrawal shall not affect any cooperation with the court in connection with criminal investigations and proceedings in relation to which the withdrawing state had a duty to cooperate and which were commenced prior to the date on which the withdrawal became effective. Palagay ko, is my reading of the subject section 127 accurate?
Very correct, Your Honor, especially yung last part na sinabi niyo, and which were commenced prior to the date on which the withdrawal became effective. Kaya nga po sinasabi ko, yun nga pong na-commence ay nangyari po noong 2021. Natapos na po ang effectivity ng ating withdrawal. Kaya nga po hindi siya applicable, Your Honor.
Ikaw mismo nagsabi na nag-commence yung preliminary examination.
No. Your Honor.
I can appeal to the records of the case. You said that the preliminary, the examination mismo ay nag-commence before the effectivity of the Philippines withdrawal. But the request for a preliminary investigation came after.
Yes.
Yes, correct?
Yan po yung ating bone of contention dahil nga po ang interpretation ng government yan ay preliminary investigation ang tinutukoy. Kaya nga po humingi ng authorization pa ang prosecutor to commence his preliminary investigation.
Okay.
Yung pong preliminary examination, sa kanya lang po yun eh. Sa parte lamang po ng prosecutor yon. Siya lamang po ang dumidiskarte doon. Pardon my word. Pero hindi pa po involved ang ICC chamber doon sa time na nangangalap ng ebidensya ang prosecutor. Hindi pa po involved ang chamber ng ICC. Kanya lamang pong sariling effort yon ng prosecutor.
Well, sa palagay ko naman, yung examination ay yun ang pagsisimula ng pag-imbestiga ng prosecutors ng ICC. And they will not proceed without the go signal from the ICC. Kaya we are trying to make a distinction which should not be made. Just so to escape our obligation to cooperate. Ngayon, palagay ko naman alam ng Solicitor General ang Philippine jurisprudence on jurisdiction.
Yes, Your Honor.
And once jurisdiction is laid or attached with the filing of a complaint, whether in a civil or criminal case, that jurisdiction continues unimpeded until there is a pronouncement by the court of its final judgment and its enforcement of its decision. Hindi ba totoo yan?
Tama po yan sa ating judiciary under our legal system. Pero ito pong sa ICC, ito po ay covered ng isang treaty. Kaya po yung ating jurisprudence on jurisdiction does not necessarily apply to an international treaty like the Rome Statute.
Yung bang interpretasyon ng gobyerno doon sa Article 127 ay salungat sa ating jurisprudence na sinusunod sa Pilipinas na ang jurisdiction, pag iyan once laid, that survives and that should not be impeded even by any delay or irregularity in the process. Iyan ang mga desisyon ng ating Korte Suprema. At iyan din ang linalaman ng Article 127 because yung Article 127 did not make any distinction whether it is yung initial examination or preliminary investigation o yung trial mismo before the ICC.
Yun pong sa parte ng ICC ay meron pong there are specific articles of the Rome Statute that deal with the exercise of jurisdiction. Yun nga pong sinabi ko na Articles 12 and Articles 12 and 13. So very specific po yung exercise of jurisdiction under the Rome Statute. Kaya nga po hindi natin magamit ng exactly kung ano po yung jurisprudence are under Philippine law. Kasi sa atin po ay kumbaga sa rules of court natin po iyan and jurisprudence, pero ito po ay treaty kaya po hindi siya talaga applicable. Yun po ang sinusunod natin, ano ho, yung Articles 12 and 13. Pero kung meron po kayong ibang interpretasyon kung ano ang ibig sabihin ng investigation being commenced by the prosecutor, kung ang inyo pong opinion ay pati preliminary examination stage ay kasama noon, then that is your interpretation, Your Honor. Kaya lamang, yun pong decision ng ICC Appeals Chamber na nangyari po noong July of 2023 ay maliwanag pong explain noong dalawang members of the Appeals Chamber na yun pong pag-exercise ng jurisdiction ay hindi na trigger on a timely basis. At yun po ay makikita natin doon sa dissenting opinion ng mismong presiding judge ng ICC.
Okay.
Unfortunately, yun pong 3 other members of the Appeals Chamber did not make any statement at all about the issue of jurisdiction. Yung pong dalawang minority, ang siyang mayroong very strong statement na hindi na exercise ang jurisdiction at the proper time. At hindi naman po pwedeng forever, perpetually na nakahang yung ganyang klaseng threat sa Philippine government. Kaya po ganon ang kanilang naging decision.
Ito naman mga articles you have cited, good Senator Solicitor General, ay article, ano nga yun?
12 and 13 po.
12 and 13
Preconditions to the exercise
of
of jurisdiction.
jurisdiction. Ito naman ay na-modify.
Hindi pa po siya namomodify.
Na-modify yan. Mismo sa room statute, doon sa article 127 on withdrawal.
Hindi po siya minomodify kasi
Not-modify yan sa
separate
pagka-
po yung 127 eh.
Natural. Pero a subsequent article, in our interpretation, a subsequent article can be construed to modify a previous article. At dito naman sinasabi na kailan mag-cooperate ang isang estado kahit na naging effective na ang withdrawal. That is very clear sa Article 27, which is subsequent to Article 12 and 13. Now, when you were the Secretary of Justice, were you privy to the appeal which the Philippines made before the ICC?
Yung sa appeals chamber po, I think I was already the Solicitor General at the time that the appeal was made. I was already the Solicitor General at the time.
So you were not privy to the appeal.
Well, I am privy to the appeal because ako po ang representative ng Republic of the Philippines.
Iyan nga ang gusto kong ma-underscore. You were the principal on behalf of the Philippines in that appeal. And as lawyers, or even as laymen, when we appeal, we are expected to respect the appeal, whether it is for us or against us. In this case, the appeal by 3-2 was against the Philippines appeal, where the court reiterated its jurisdiction. Is that correct?
No, dahil wala nga pong aspect yung decision ng appeals chamber na nag-deal with the issue of jurisdiction. Kaya nga po yung issue ng jurisdiction nakahang until now. At yun po ang basihan kung bakit hanggang sa ngayon ay pinapangatawanan ng Philippine government na walang jurisdiction dahil hindi na-exercise po yung jurisdiction na yan at the proper time. Wala pong aspect yung decision ng appeals chamber dealing with the issue of jurisdiction. Kasi in-skirt po yan nung tatlong, yung 5-member chamber. Yung tatlo po na majority did not make any statement at all about the challenge to jurisdiction. Ang sinabi lang po nila, this is not the proper time to address the issue of jurisdiction. Kaya po nakahang yung issue ng jurisdiction until now.
Yung principal question ng ating gobyerno hinggil sa appeal ay walang jurisdiction ang ICC over the country because it has already withdrawn from the Rome Statute. Is that correct?
Hindi lang po yun.
Isa yan.
Isa po yan.
Isa yan.
Isa po yan.
Ngayon, in essence, ano ba yung decision, majority decision ng ICC?
Ang essence po ay pwedeng ipagpatuloy ng prosecutor ang kanyang investigation.
Okay. Iyan nga. So, in that sense, natalo ang Pilipinas. At obligasyon ng Pilipinas, tayo ang nag-appeal, sundin natin ang desisyon ng ICC. Otherwise, bakit mag-a-appeal pa tayo kung hindi natin susundin ang desisyon? Ang desisyon ay ipagpatuloy ang investigasyon. Kaya ang desisyon ay kailangan din mag-cooperate ang Pilipinas sa investigasyon. I think we should not be a renegade in the international community, but we should subscribe to the principle of the rule of law. Pag nag-appeal ka at tatalo ka, tanggapin mo ang desisyon at sundin mo.
May I say something about that?
Yes.
Tayo naman po ay sumusunod doon sa decision na yon ng appeals chamber. Ano po ba ang decision ng appeals chamber? Mr. Prosecutor, you may continue your investigation. So, ang Pilipinas naman po, hindi naman pinagbabawalan yung prosecutor na magpatuloy ng kanyang pagsisiyasat ng investigation. Dahil yun po ang decision ng appeals chamber. Hindi naman po natin siya pinagbabawalan na magsiyasat. Ang sinasabi lang po ng Philippine government, dahil may issues kami ng jurisdiction na hindi na settle dyan sa decision na yan, wag kang mag-expect ng cooperation from us. Pero hindi kita pinipigilan na mag-continue ng iyong investigation dahil yan ang naging decision ng appeals chamber. You can investigate in whatever way you want. You can talk to any person you want. You can interview any witness you want. It's up to you. Ang sinasabi lang po natin dito, but do not expect cooperation from the Philippine government. Yun lamang po. Hindi naman po natin sinusuway yung decision ng appeals chamber. Hindi po natin pinagbabawalan ang ICC prosecutor to proceed with his investigation.
Okay. Hindi ba isa sa mga issues ng Pilipinas doon sa appeal ay gusto nating pagbawalan ang investigasyon ng ICC prosecutors dito sa loob ng bansa?
Sinasabi po kasi natin ay hindi admissible yung kaso dahil nga po ang may primary responsibility to investigate ay ang sarili nating national institutions. Kaya po hindi tayo pumapayag na sila ay mag-investigate. Pero ganyan nga po ang naging decision. Kaya po, sige, di mag-investigate kayo kung gusto niyo mag-investigate.
Mag-investigate hanggang dito sa Pilipinas.
Opo, syempre.
Siyempre. Ang gusto lang niyo sabihin,
Congressman Lagman, can I just make it clear in relation to what you're asking? Kasi hindi masyadong malinaw sa akin eh. So yung pinag-uusapan natin ngayon na Solicitor General na ayaw makipag-cooperate ng Philippine government sa ICC pero pinapayagan sila mag-imbestiga. Yun ba ang gusto mo sabihin?
Yes, hindi naman po natin pinagbabawalan na mag-investigate yung prosecutor dahil yun po ang...
Therefore, naniniwala din kayo na may jurisdiction ang ICC na mag-imbestiga kahit na hindi mag-cooperate ang gobyerno?
Kahit po hindi makipag-cooperate ang government. Ang basihan po kasi ng lack of cooperation ay dahil nga po until now ay china-challenge pa rin natin ang jurisdiction ng ICC dahil po hindi niya na exercise yung jurisdiction na yon sa tamang panahon. Hanggang ngayon po ay yon ang ating pinapangatawanan. At wala pong aspeto yung decision ng appeals chamber tungkol doon. Kaya hanggang ngayon po yun ang ating mine-maintain.
So ibig sabihin na firm pa rin kayo sa inyong paniniwala na dahilan sa nag-withdraw ang Philippine government noong panahon ni President Duterte ay dapat hindi mag-cooperate ang Philippine government at dapat hindi mag-imbestiga ang ICC.
Hindi po. Ang sinasabi po namin, there is no legal duty on the part of the Philippine government to cooperate. Yun lamang po ang sinasabi namin.
Okay. Maliwanag naman yun, Mr. Chairman, na ang sinasabi ni Solicitor General, pwedeng mag-imbestiga ang ICC, conduct the preliminary investigation dito. Makalagay ko, dito naman ang mga ebidensya, dito yung mga testigo. Pero ang gobyerno ay hindi magko-cooperate sapagkat wala silang legal duty. Kahit na admitted naman na doon sa Article 127, may legal duty ang Pilipinas to cooperate in the investigation. Ngayon, ang sabi ng Solicitor General, Mr. Chairman, ay meron pang question sa admissibility or yung complementarity.
Jurisdiction and admissibility.
Okay, okay. Yung sa complementarity, wala nang problema ba yun?
Hindi po, until now, we maintain our position kasi na ang may primary responsibility ay ang ating mga national institutions.
Okay. Pero doon sa complementarity, hindi naman tinutukoy yung the whole gamut of the judicial system in the Philippines that it is working or it is not working. Ang tinutukoy lamang ay tungkol doon sa kaso before the ICC. Kung yung bang respondents ay being prosecuted or being tried in Philippine courts. That should be the context of complementarity. Si former President Duterte ba at sila yung mga kanyang major correspondents ay meron ng prosecutor na Pilipino, prosecutorial office na may nakapending na reklamo laban sa kanila na iniusig.
As far as the former president is concerned, Your Honor, wala pa po dahil wala pong nagfa-file ng complaint against him. Nung time na siya ay presidente, that's understandable dahil siya po ay may immunity from suit. Pero ngayon po na hindi na siya presidente, wala namang nagfa-file ng complaint sa kanya.
Yung gobyerno ba mismo, yung prosecutor mismo ay hindi pwedeng mag-file on their own sapagkat merong krimen na naganap sa Pilipinas under our laws and our international law?
Ang ating usual procedure po ay merong complainant, halimbawa yung biktima, kung sila po ay nag-allege na ang presidente ang siyang pasimuno ng lahat ng ito, ay sila po ang dapat na mag-file ng kaukulang complaint.
Motu proprio ang gobyerno hindi pwedeng mag-file? Pinagbabawal ba yan?
Kasi po hindi po yun ang ating normal na proseso na mag-iimbestiga, magko-conduct ng preliminary investigation ang ating prosecutor nang wala namang nakahain na reklamo sa kanyang opisina. Ano po ang kanyang iimbestigahan kung wala naman pong nakahain na reklamo?
Okay. Yung bang ibang mga respondents maliban sa former president wala rin kaso sa prosecution sa prosecutor's office?
Depende po sino po bang mga tao ang
si Senator Bato ba meron?
Wala po.
Wala.
Wala naman pong nag-file ng any complaint against him.
Okay. Meron ba naman na nakapending na kaso sa husgado sa Pilipinas laban kay former President Duterte at mga kanyang correspondents hinggil doon sa crimes against humanity tungkol sa deadly war on drugs?
Let me just clarify this, Your Honor, kasi yung iniimbestigahan po ng ICC ay ang Philippine situation in general. Wala naman pong any specific persons na tinutukoy ang ICC prosecutor sa panahon na ngayon. Kaya nga po siya magko-conduct ng investigation with the end in view of specifically identifying certain individuals at a later time. Pero wala pa po tayo doon eh. Wala naman hong ina-identify ang ICC prosecutor na specific persons na siyang papaharapin sa ICC trial chamber kung kinakailangan. Sa ngayon po, wala pa po tayo doon sa stage na yun. It's the Philippine situation being looked into by the prosecutor. Kaya po hindi po parang wala pong parallelism na tanungin kung meron na po bang domestic complaint against Senator Bato or meron na po bang local case against the President. Kasi even the ICC po, wala naman po silang ina-identify pa na certain persons na kanilang lilitisin sa trial chamber.
Doon ba sa mga complaints, gusto mo sabihin ng complaints, hindi kaso, complaints na pinail sa ICC, meron bang mga tinutukoy na respondents?
Actually, hindi po namin nakita at all yung mga complaints na yon na inihain sa ICC prosecutor. We were just informed na merong investigation or examination na gagawin ang ICC prosecutor. But we never saw yung complaints na yon. Nalaman na lamang po namin sa mga media reports na ang subject matter noong mga complaints na yon ay mga certain individuals like the former president, I think certain PNP officials, Senator Bato de la Rosa. Yun po ay nag-gather na lamang namin from media reports. Pero hindi po yun as in binigyan ng kopya ng reklamo ang Philippine government para po makapag-comment naman kahit papano ang Philippine government. Hindi po nabigyan ng ganong klaseng opportunity ang Philippine government nung time na nag-gather po ng facts or ng evidence yung prosecutor.
Ang gusto mong sabihin, Solicitor General, at the initiative of the Philippine government or its officials, hindi kayo kumuha o humingi ng mga complaints sa inyo para malaman ninyo kung ano talaga ang linalaman ng mga complaints?
We did. As a matter of fact, we requested copies of these complaints.
And you were also given copies of the complaints?
No, we were not given copies of these complaints. Until now, Your Honor, I have not seen a copy of any of these complaints.
Sino ba sa mga resource persons ay may copy ng mga complaints na ito?
Mr. Chair, copy of
The
the
complaints sa ICC.
kami, Mr. Chair, may copy kami ng complaint namin and of course the complaint of Attorney Sabio. Maybe Attorney
Pakibigyan mo nga si Solicitor General para malaman niya kung anong linalaman ng mga complaints na yan.
Yes, Mr. Chair.
At bigyan mo rin ang joint committees ng kopya ng mga complaints na yan.
Yes, Mr. Chair.
Pinag-uusapan natin na kayo lang ang nakakakita.
Yes, Mr.
Okay.
Chair. At saka I'd just like to add, Mr. Chair, if I may, yung Department Circular 20-A lang ng DOJ about motu proprio investigation if in the information of the DOJ a crime has been committed. Parang wala akong nakita na need of a complainant dito. And in fact, the PNP is even motu proprio also required to investigate under the Department Circular if kahit walang complainant, if they feel that there's a crime being committed. So yun lang, Mr. Chair, gusto kong i-add thousands of deaths. And I think that's enough information to at least initiate an investigation despite the absence of
Attorney Larry, ilan
Mr.
po ang complaint na na-file ninyo?
Sa ICC po, isa po. But it involves about 7 families of the AJK victims and of course Rise Up for Life, the church NGO, Mr. Chair, who initiated it.
Are there others nag-file ng complaints sa iba? For example, like Attorney
Sabio.
Yes, Mr. Chair.
meron po ba?
And there could be others who filed, but because probably for some reason, like they are afraid to be known, they did not announce it. But it's really possible that there are many other complaints filed either before Attorney Sabio or after 2017. We don't know. But we have information that there are other victims who went there, except that unlike the Rise Up for Life and Attorney Sabio, they did not disclose their identities, Mr. Chair.
So the request of Congressman Lagman na bigyan nyo ng kopya si Solicitor General Guevara on the complaints, can you do that?
We will do that, Mr. Chair.
And please give a copy to the committee also.
We will do that,
Mr.
Mr. Chair. Salamat.
Gusto ko lang pong balikan yung tinatanong kanina ni Honorable Edsel Lagman. Yun po kasi doon po sa mga libo-libong insidente na mayroong napatay sa mga police operations na may kinalaman sa war on drugs, ang PNP po, na andito ang representative ng PNP, automatically po yung kanilang Internal Affairs Service ay nagko-conduct ng kanilang sariling investigation, at kung sa tingin nila ay merong parang lapses or hindi tamang pag-conduct ng kanilang let's say police operations, ay pinapatawan naman po nila ng kaukulang disciplinary action, or kung kailangang i-file sa kaso sa DOJ ay ginagawa nila. Pero nung pong time na ito ay naging mainit na issue, ang ginawa po ng DOJ, ako po yung Justice Secretary at that time, hiningan po namin ang Internal Affairs Service ng PNP ng lahat ng kanilang investigation reports tungkol sa mga killings na incidental to the conduct of police operations. At sila naman po ay fortunately nagpa-unlock. So ibinigay po nila sa DOJ at least 56 cases na ang tingin nila ay may possible liability yung mga police officers involved. On the part of the DOJ, nung matanggap po namin yun, Congressman Edsel, ang ginawa po namin, dahil yon ay initial examination lamang ng PNP, nirefer po namin sa Philippine as a National Bureau of Investigation for case build-up. Kaya po doon sa proseso na yon, na mayroong sariling investigation, automatic ang Internal Affairs Service napunta ng DOJ, DOJ inassign sa NBI para po mag-case build-up. Meron pong mga kaso resulting from that na na-file ang formal complaint sa DOJ for preliminary investigation, at yung ibang kaso po ay nakarating sa husgado. So yun po yung proseso. Hindi naman po talaga as in walang gagawin ang DOJ kundi maghintay. Dito po sa situation na to ay ugnayan po kami sa PNP para po kunin sa kanila yung mga reports ng kanilang initial investigation.
Mr. Chair, can we ask Congressman Lagman to ask questions second round so we can give opportunity for the others to ask questions too?
Sige, I just would like to just sum up my questions.
Okay.
If I have, may I just ask for a few minutes extension?
Go ahead, Congressman Lagman.
Let me go join chairs to the reason for the 1 year after effectivity of a withdrawal. I think one of the reasons would be to prevent a state from malevolently withdrawing, so that yung cases covered will not anymore be under the jurisdiction of the ICC. Is that correct?
It appears to be one of the reasons for the 1 year period.
Another reason for the 1 year period is to respect complementarity, so that in that span of time, the domestic jurisdiction can investigate, prosecute, and judge the offenses covered under the ICC. Is that correct?
Possible reason for the 1 year period,
Okay.
Your Honor.
So I will ask for a second round, Mr. Chair.
Thank you, Congressman Lagman. We would now like to recognize Congressman Bongalon of the party list Ako Bicol.
Thank you, chairpersons. I will reserve my right to ask questions later, and I will give way to the members of the minority to ask questions. Thank you.
Thank you, Congressman Bongalon. Now we would like to recognize Representative Bordado. Sir.
Thank you, Mr. Chairman. I am directing my question to the representative of the Department of Justice. Some clarificatory questions, Mr. Chairman. You're telling us, Madam Prosecutor, that the DOJ is focusing on 7,000 plus cases. Is that correct?
Sir, yes, because this is the figure, this is the number that was submitted by the Philippine National Police, the Directorate for Operations. Ito po yung naging initial number na nakuha nila out of the big universe of incidents that involved that was involved in the drug war, sir. So I cannot even categorically say how kung ilang 7,000 po kasi this is actually a moving number. From what I understand po, yung ating mga personnel from the PNP continue to process these cases, and together with the panel that was created by Secretary Remulla, we will sit down with the Philippine National Police personnel as well as the PDEA personnel, the DDB and NBI, just to get the figures straight.
So ang ibig sabihin, Mr. Chairman, wala pa tayong definite number.
Depende po kung ano po yung pag-uusapan po ata natin. From what I understand, meron pong system ang Philippine National Police, which is sifting the incidents into depende po kung ano ang gusto nating makuha. Halimbawa po, incidents involving warrants of arrest, incidents involving buy-bust operations lang po. Sino ang namatay doon? May pulis ba doon? Walang namatay? O
Mr.
ganun
Chairman,
po ang processing.
Mr. Chairman, let me just clarify. Ilan ba ang namatay in connection with this so-called war on drugs?
Depende rin po siguro kung kung sino pong namatay ang pinag-uusapan natin. Mga subjects po ba? May mga police din po? Because from what I understand, the Philippine National Police has those figures po.
So in other words, Mr. Chairman, the Department of Justice doesn't have the data.
We have, sir, the initial data, but if this is the clear and final number, we cannot say for sure that this is it po. So like I said po, we are continuously working with the Philippine National Police in cleaning up the numbers.
Kasi Mr. Chairman, iba-iba ang mga data, iba-iba ang mga numbers na nababasa namin. May nagsasabi na 6,000 ang namatay. Sinasabi mo po kanina 7,000. And may man nagkiklaim na umaabot sa 10,000. So what is the real number? Can you give us a number which is close to reality?
Sir, kung ang pag-uusapan po natin yung pinakahuli pong numero na ibinigay po ng Philippine National Police, meron po ako ditong pwedeng maibigay na from July 1, 2016 hanggang June 30, 2022, meron pong 7,732 fatalities involving drug personalities po sa kanila. 732.
732. So sa 7,732 cases of deaths, ilan bang kaso ang i-file na?
Pwede po ako mag-refer sa Philippine National Police ng updated number po natin.
Yes, madam. Thank you.
Sir, with regards po sa sa query po ninyo, unfortunately, wala po kaming kasamang from the Internal Affairs Office. Sila po sa palagi ang kan. By the way, we will but we will coordinate with the IAS to get the records, and we will submit it to this committee, sir.
Yeah. Mr. Chairman, this is quite unfortunate. Now, we don't have any data on the number of cases filed by the PNP or by any authorized entity regarding the incidence of deaths in connection with the so-called war on drugs. Mr. Chairman.
I'd like to ask the Department of Justice, yung binanggit mong 7,700, ano yung mga napatay na yun?
Opo.
So, that should be admitted that more than 7,700 were killed on the war on drugs. Ilang taon yun? For how many years?
Mula po ito, sir, ng 2016 up to 2022.
Okay, meron ba kayong listahan ng mga napatay ng mga sa drugs na malalaking tao? Drug traffickers, yung mga bilyonaryo, yung mga milyonaryo, meron pa po kayo listahan, no?
I believe po there is a set of data with the Philippine National Police.
Pero
Hindi
wala
ko
po
lang
sila eh.
ma-point out.
Wala po sila eh.
Sabi ko po kasi kanina, ang interagency group po na pinatawag ni Secretary Rimulya ay patuloy pa pong nagpa-process ng mga kaso. So I cannot say offhand kung meron pong mga high level or high value targets, but I am sure po meron. Hindi ko lang po masabi kung yung pangalan and yung number specific po, but I am sure there are.
Meron pa po ba, Congressman Bordado? Have any more questions?
No, thank you very much, Mr. Chairman.
Thank you, Congressman Bordado. We would now like to call on Representative Adyong for your questions.
Thank you, joint chairpersons. I'd just like to ask few clarificatory questions, perhaps to help me understand, Mr. Chairman, what transpired during the filing of the complaint and after that, before and after the withdrawal of our government from the ICC. Now, I have seen several dates, Mr. Chair, and I think it's essential, Mr. Chair, that we understand and appreciate the importance of these dates so that we may able to appreciate fully the subject at hand. First, Secretary Guevara mentioned about the differences in terms, the understanding of what jurisdiction is and how the ICC can exercise that jurisdiction. If I heard it right, the filing of withdrawal was on November 17 of 2017. Is it correct? Or 2018?
Yun pong notice of withdrawal ay ginawa noong March 2018 at nag-take effect po noong
After 1
March
year.
of 2019.
Okay. So, ibig sabihin po, is it safe to assume, Secretary, that once we've withdrawn from the Rome Statute, our government will no longer cooperate in, sabi nga ng Presidente, in shape or in form in relation to the investigation or the complaint filed before the ICC. Tama ho ba?
Kung meron pong preliminary investigations na simulan na bago nag-take effect yung ating withdrawal, then magtutuloy-tuloy po
Okay.
yun.
Yeah.
Opo, pero hindi po ganun yung nangyari sa case ng Philippines.
Okay. Sige, ibig sabihin, kanina po tinatanong ni Manong Edsel about yung pinapaklarify niya, Mr. Chair, the difference between the examination and the actual investigation.
Yes.
I think the exchanges, what I gathered from the exchanges between Congressman Edsel and the good secretary is that the jurisdiction has already been agreed upon, no? Tama po ba?
Yung jurisdiction over the subject matter, over the offenses, hindi po disputed yun.
Okay.
Talagang may jurisdiction po over the, let's say, alleged crime against humanity. During the period na miyembro po tayo, wala pong issue
Okay.
tungkol doon.
So, big sabihin, let me ask Mr. Chair, Congressman Colmenares, if I may. Earlier po, Attorney Colmenares, once a congressman is always be a congressman, sabi nga nila.
Salamat po,
Yes
Mr.
po.
Chair.
Congressman Colmenares, earlier you presented to us a series
Yes
of
po.
slides. In one of the slides, it indicated several dates. No, tama po ba?
Yes, Mr. Chair.
Yes, particularly on slide number two. There are several dates here where, according to your presentation, our government requested for an extension of a 30-day, giving the OTP requested the Office of the Prosecutor to defer the investigation for 30 days, giving our country, I don't know, to whether to do an investigation on our own or not. So is it right po yung pagkaintindi ko po?
Yes, Mr.
Okay.
Chair, you're right.
And then on December 22, maybe a month after that, our government also again requested for another extension.
Yes, Mr.
Is it
Chair.
correct?
Correct, Mr.
Would
Chair.
you know, Congressman Colmenares, which agency of the government made that appeal before the ICC request for an extension?
Well, I think if I may be correct here, Mr. Chair, the Solicitor General at the time was the one who represented the Philippines
Okay.
in the ICC.
Okay, Mr. Chair, Secretary Guevara, I'm sorry, I need to go back to you. Okay?
Yes, Your Honor.
Help me understand, because as a non-lawyer, my understanding of recognizing jurisdiction, or if assuming that we have already withdrawn from the Rome Statute,
Mhm.
and I assume based on the dates given to us by Congressman Colmenares,
Mhm.
we have already,
Withdrawn.
kumbaga, yung membership natin have already been revoked. Sorry,
Withdrawn.
pardon for my lack of
Mhm.
vocabulary. No, we have already withdrawn. This is 2 years after the November 2019, where the withdrawal took effect. Why do we keep communicating with the ICC, requesting them for an extension of an investigation? If so, we do believe that we do not want to cooperate with them insofar as this investigation or this complaint is concerned. Why do we keep requesting the ICC for an extension if our position is that the ICC has no jurisdiction over this case?
Thank you, Your Honor, for asking that question. Let's remember that this deferral happened when the Republic had already effectively withdrawn. But we did continue to engage with the ICC prosecutor purely out of committee. We wanted to show to the ICC that we shared their vision of ending any alleged impunity happening in our country. But in all of this further engagements with the ICC prosecutor, notwithstanding that our withdrawal had taken effect, we made it very clear to the ICC prosecutor that we are not waiving any challenge on jurisdiction. We are just doing this so that you may be properly apprised about what the Philippine government is doing. So in fact, we submitted so much information about investigations being conducted by the PNP, by the NBI, by the DOJ, what cases had reached the court, and so forth and so on. We did that twice because we needed more information to submit to the ICC prosecutor, just to make him think that the Philippine government is doing what it was within its power to do. But notwithstanding all our submissions, it seems to me personally, if I may say so, that the ICC had already taken a stand that all of this is insufficient. We are being straitjacketed into a certain period of time within which to come up with results. That is not possible because we are following our own system of investigation and prosecution.
Yes,
We have to follow that process, Your Honor.
yes.
So while we have submitted all of this information for them, this is still insufficient. We are not convinced. That is the point of the ICC prosecutor.
Well, thank you very much for that. I appreciate your response, Secretary Guevara. Although for me, if it's only a matter of cordiality of our government being, because we've been a signatory to many treaties upholding human rights, I would understand if the communication or the exchanges between our country and ICC would merit only cordiality. But the communication in the exchanges really speaks about request of an extension. To me, by request of an extension would in a way acknowledging a certain power of such entity over our country. You do not request, Mr. Chair, for an extension if you do not at least recognize jurisdiction or authority over specific particular case, Secretary. So that is what I'm having trouble understanding.
Yes.
Mr. Secretary, sabi ko nga, if it's a mere cordiality, we're talking of cases that involves crimes against humanity. This is huge. And a request from the government would necessarily entail, pardon my limited understanding of the international law or the law, but as using a common sense, as a layman, I would not ask for example, for you not to, because asking Mr. Chair, an extension gives you the prerogative and the power to do something over me. That is my understanding as a common person. So help me understand again, Mr.
Well,
Please.
Your Honor, as I already explained, notwithstanding that we made this request, we made it very, very clear to the ICC prosecutor that we are not waiving our
Right.
challenge
Okay.
to the jurisdiction. We simply wanted to show to you that we're doing something.
Okay.
That's all.
Thank you. Thank you. Thank you for this one. Mr. Secretary, earlier you said, I guess, as a response to Manong Edsel, no? And correct me if I'm wrong. This is what, if I heard it correctly, your response. You said the country will not, meaning to say, we do not have a duty, a legal duty to cooperate with the ICC. Should there be an investigation that would take place? Is that correct?
Yes, Your Honor.
Yes, we will not cooperate. But did I also hear it right that you will not barge the ICC from conducting its investigation?
That is what the pretrial chamber said, that the prosecutor may
Okay.
continue his investigation.
So assuming, Mr. Chair, Secretary Guevara, assuming that there's going to be an investigation, assuming,
Mhm.
and our country will not cooperate, and yet we will not stop them from investigation. Help me understand how that would transpire.
Well,
In what way can that be possible?
the prosecutor has all the means.
So they can come
he
here.
can do online, he can interview witnesses.
But we will not, meaning to say we will not provide the investigators materials in relation to the cases that they are about to investigate, or they will be investigating the country.
Because exactly that is the government cooperation that may be requested, asking for official documents or asking that notices be effected through the government machinery. or trying to locate certain people, and so forth and so on.
Okay.
So the prosecutor can do that on his own.
But we will not simply open up our agencies, for example, and then help assist investigators.
That
of
is the meaning of
N-
non-cooperation
okay.
on the part of the government.
Okay, thank you for helping me understand that and put that into context. Mr. Chair, Secretary Guevara, there was already a case. I guess the good secretary also mentioned it earlier in his opening remarks regarding Pangilinan versus Cayetano. And in that ruling, the Supreme Court again also confirmed, just been confirmed by the secretary that prior to the withdrawal, when the complaint or the allegations covers a certain period of time prior to the withdrawal, ICC has a jurisdiction to investigate. Is it correct? That's what I understand.
Yes.
Yes. So
Yes, Your Honor.
even without, for example, with all due respect to the authors of these three resolutions, even without this resolution, there's already a Supreme Court ruling and decision regarding this. Would, for example, the government accede to that? Or was there any chance that the government would probably entertain the possibility, since the Supreme Court, the highest court in our land, has already rendered its decision?
Let me
Can
clarify.
it be enough for the government, for example, to at least put primacy to whatever, or at least not primacy, but favorably act upon the decision of the Supreme Court?
Not enough, Your Honor.
Not enough.
Not enough.
Also,
Would you like me to explain?
yes, please, Secretary.
Your Honor, Cayetano versus Pangilinan dwelt with the singular issue, just one issue, whether the withdrawal of the Philippines from the ICC or from the Rome Statute was valid. The withdrawal unilaterally by the president, that was the only issue in that case. And the Supreme Court came up with a decision in 2021 after the effectivity of our withdrawal. So how did the Supreme Court deal with that case? The Supreme Court said this petition filed by Senator Pangilinan is dismissed because it is moot and academic. Right. But in the process, the Supreme Court made certain disquisitions about certain obligations, etc., which are not directly related to the issue at hand. So lawyers call that statement coming from the Supreme Court, which is not directly related to the issue at hand, as obiter dictum. And an obiter dictum does not result in a doctrine or a ruling that can be enforced. It is not the source of any judicially enforceable right. So it is mere obiter. And if I may say so, it was incomplete because the Supreme Court said that the ICC would retain jurisdiction over offenses that were committed during the time that the Philippines was still a member. However, the court did not make any explanation as to when this jurisdiction can be exercised by the ICC. So to that extent, hindi rin po kumpleto yung obiter dictum na isinama ng Supreme Court doon sa decision, which simply dismissed the petition for being moot and academic. All the other discussions were not related to the issue at hand.
So in other words, Mr. Chair, para lang pasimple po, no? Para pasimple. Ibig sabihin, una, hindi siya enforceable.
Hindi siya doctrinal ruling
Yes,
of the court in that case, and therefore need not be followed.
Okay. So hindi siya talaga enforceable. In other words, hindi
Yeah.
siya
Yes,
enforceable.
it may be persuasive, Your Honor, it may be persuasive, but that is not the doctrinal ruling of the court. In other words, if an actual case is brought before the court on that particular issue, then things may be different.
In other words po, the government, the executive branch is not it's kumbaga,
It's not bound. It's not
yeah, it's not
It's
obligated.
not bound by that
Okay.
obiter.
Okay, thank you, Mr. Chair. Now, the reason why I guess, based on my simple understanding and humble understanding on on these three resolutions and the case where the government is actually arguing why there's no need for the ICC to investigate is because of the case, it's been already cited, no, and it's been cited currently today, na yung issue of sovereignty, no. I guess that's the main point ng sinasabi nila, the courts is very functional, we are nag-ooperate and in a robust condition, so there's no need for the international or alien entity for that matter. So again, for my use of word, na pumasok dito because our courts is very much alive and kicking and in a robust condition. Earlier, I heard Congressman Colmenares, you said it was your decision to advise your clients not to file the case before our courts. Is it correct?
Yes, that is correct, Mr. Chair.
And did I hear it correctly that because of the immunity that you have cited earlier, that's why you have advised your clients not to file it before our regular courts here in the Philippines?
That's one of the reasons, Mr.
That's one of the
Only
reasons.
one, Mr. Chair, among others, Mr. Chair.
I do agree with the argument, Mr. Chair, 100% na solid po ang korte natin, na nag-work po ang ating korte, na meron ho tayong justice system dito. Congressman Colmenares, given the fact that the one that you have mentioned has already been out of office, would you still maintain your advice to your clients to continue on filing the case before the Supreme Court, before the ICC? Would you advise this time around your clients to file it before our courts?
That is a matter for them to decide, Mr. Chair. We're just the counsel. However, the issue of trust, Mr. Chair, is also there. For example, just the question of Congressman Bordado. How many were killed? 7,732. How many cases were filed? And the DOJ doesn't even know. The PNP doesn't know. So the impression of everybody is, it's not, you may be working, the judicial system may be working, but you're unwilling. So that's another matter that the families of the victims will have to decide. But this is not very encouraging, Mr. Chair. I mean, it's 2016. It's now 2023. And the DOJ cannot even give a straight answer, Mr. Chair. Of the 7,732. In fact, this is the only time that I know that there's 7,732. Under the rules, even the rules of engagement of the PNP, for every death in the execution of a search or a warrant, there must be an inquest. That is in the rules of engagement. So the question to the PNP and the DOJ, how many inquests out of 7,732 have you conducted? Because it cannot be done, Mr. Chair. You know, the moment a death is there and the official involved say, it's self-defense. Okay, self-defense. Nanlaban, okay, di tapos. No, that's not what the rules say. That's not what the law says. The law says, well, that is his defense. But you go to court, you killed somebody. I'll charge you with murder. When you go to court, you present your evidence and say, well, nanlaban eh. But it's not, hindi pwedeng ine-entertain ng rule of law at the very least that you killed somebody and yet no charges will be filed against you on your mere say-so na nanlaban kasi self-defense lang yon. That's not how it is, Mr. Chair. And so we were expecting out of 7,732 cases, 7,732 deaths, 7,732 cases were filed, and maybe 2,000 were acquitted because it's self-defense. The 3,000 is still pending. But you cannot say we only filed what 56 if I don't know how many were filed. In fact, until now, I don't even know how many were filed. So that is an issue that must be settled by not just probably the victims themselves, but the families also, because that goes into the very question of of kita nyo naman po, Mr. Chair, kanina, genuine investigation and prosecution. So I guess we'll ask them later on, but the way we're going today, it's not encouraging, Mr. Chair.
Thank you, Congressman Colmenares. That would be all, I guess, Mr. Chair, Ms. Joint Chairperson. Thank you, Secretary Guevara, for your candid response. Thank you.
Secretary Guevara, can you please enlighten me on this?
Yes, Your Honor.
One of the reasons why I filed resolution 1477, I call it exact global accountability. Layman's language tells us that what's happening now is a nagging problem already for how many years? In fact, when the president, Duterte, was the president, I've always supported his decision on this. But, Mr. Secretary, it has been 7 years now and still going on. And I was wondering when is it going to stop? The thing is this, the ICC does not agree with our point. Now, I believe that the criminal justice is working in the Philippines. But sinasabi ko nga dito, our cooperation with the ICC reflects our willingness to be transparent and responsible on the world stage, because what the world sees now is what the ICC tells them, what not the Philippines tell them. I'd like you to tell me about that. Do you agree with that, Mr. Secretary?
I'm sorry, Your Honor, but not quite. Not quite. Dahil ang ating Philippine government naman po ay nag-submit ng necessary information sa ICC Prosecutor's Office. Kaya nga lamang po ang tingin niya ay insufficient yung ating ginagawa. Just to supplement po yung...
Let me interject, Secretary. Yeah, you mentioned that, no, kanina. You mentioned that kanina. Pero alam niyo naman ang ICC, may question din dyan eh. Di ba? Sabihin nila, hindi naman enough yung information na binibigay niyo sa amin. So why don't you allow us to go there and have our own investigation?
Well, ay viewpoint nila yon, ano po. Pero tayo naman ay merong pinakita talaga na actual na information na mapagbabasihan nila kung tayo ay kumikilos o hindi kumikilos. As of, for example po, as of October 2023, yung pong naunang priority cases na galing sa PNP, 56 ng laban cases. 25 were closed for lack of interest on the part of the complainants or requesting party. 19 cases are still pending investigation. 12 cases were filed before various courts and prosecutors' offices. May conviction na po dyan kina Arnaiz, kay Kulot de Guzman, may case for homicide against for the death of Crispin Vedanio, may criminal case against a police officer for the killing of a certain Garbo, the filing of information for the murder of certain Sawadjahan, Bacalso, and Hofer, for the death of Leo Morata, public police officers who were involved in the killing of Richard Santillan and Casing are currently on trial for murder before the RTC of Cainta. Information for murder was filed against police officers involved in the killing of a Spanish national by the name of Diego Lafuente. Cases for murder were filed in the case for the death of a certain Elpidio Sevilla Francisco, etc., etc. 250 other non-laban cases were investigated by the NBI Bulacan District Office. But quite unfortunately, Your Honor, according to the NBI, 70 to 80% of these cases in Bulacan were left hanging because the victims' families could not be located or were uncooperative. In the entire Central Luzon area, 58 cases are under investigation. So in short, Your Honor, these are being done by our investigative agencies. It's just that konti pa lang po yung nakakarating sa ating mga husgado because we have a certain process to follow. Yung pong sa preliminary investigation could take some time. And sometimes these are appealed by way of certiorari kung meron pong finding ng probable cause. So it's because of our process. Hindi naman po pareho ang proseso natin at ng ICC. Yung kanila po kung ano ang gusto nilang gawin. Kung gusto nilang mag-investiga, kung gusto nilang magpa-aresto kaagad, they can do so. Pero yung sa atin po, hindi ganun yung process. And our process needs time. Parang na-straight jacket nga po tayo. Binigyan po tayo ng panahon para pakita na may ginagawa tayo. Pinakita naman natin na may ginagawa tayo. Kaya lamang wala pang nakakarating masyadong marami sa mga courts dahil nga po may process. So, maring ito po ay hindi katanggap-tanggap. Maring ito po ay kulang sa paningin ng ICC. Pero hindi naman po ibig sabihin na wala naman tayong ginawa. I hope that the DOJ and the law enforcement agencies are now exerting greater efforts para po masabi naman talaga na ito namang ating sistema ay nagpa-function.
So, John, can I just cut you there? And
Sige po.
because the numbers that you mentioned, no, although it's less than 1,000, the figures that you just mentioned now, and that they were claiming that there were 7,000 plus deaths. No? And what I find strange, Mr. Soljan, is the fact that when the PNP and the DOJ were asked about this, no one seemed to have any clue as to the number of cases that were filed. And it strengthens the suspicion kasi that our government agencies are not doing enough. Now, knowing that this is an issue that has been hounding not just this administration, but the previous administration also, parang it presupposes that we take it seriously and that we have the figures at hand, no? So I was going to ask the figures from the PNP and the DOJ to be submitted to the joint committees, but since you already mentioned it, can you please furnish the joint
Yes
committees
po.
with copies
Ito
of
po
those?
ay as of October 2023 at ito po ay base lamang sa information available to the OSG. Pero syempre po ang higit na makakaalam dyan ay ang ating mga law enforcement agencies at ang DOJ.
So then
Dinolunteer ko lang po ito
Okay.
para merong idea kayo na ito naman ang ginagawa. ng
Yes, sir.
ating
So we
gobyerno.
will be directing the PNP and the DOJ to please submit the figures, no, asked by Representative Bordado earlier.
Mr. Secretary, nabanggit mo kanina, yun ang palagay ng ICC, di ba? I mean, I do not question the process of our legal system here in the Philippines. What I question is the reputation we're having abroad. Whether we like it or not, the reputation we have right now is better believed with what the ICC says. So sa akin, the resolution is, so why don't we allow the ICC to come here, investigate, get the information to find out that they are wrong? Are they wrong or right? Are they wrong or right?
Well, we believe, Your Honor, that the ICC has no
No,
factual.
but please,
There's no
please
fact-
answer.
yes.
Are they wrong or right?
In what, Your Honor, to be more
It-
specific?
In their supposition and in the prosecution that they would like to conduct, are they wrong or right? Are they wrong in all the accusations being hurled against by our attorneys here, being hurled against some against the government to the ICC?
Well, the
Yung-
ICC,
yung po ang kanilang reputasyon, ang kanilang palagay sa atin, tama ba sila o mali?
the ICC is wrong
If they're
in
wrong,
concluding.
if they're wrong,
Opo.
Let's allow them to come here to prove that they're wrong.
Hindi po hindi po ganun eh. Sila po ay mali in the sense na ang tingin nila ay hindi unable and unwilling ang ating judicial and legal system. Doon po sila mali. Kaya ang dapat na gawin natin para ipakita natin na mali sila ay hindi papasukin sila, kung hindi strengthen yung ating ginagawang investigative and prosecutorial functions.
Do you mean to
Yun
tell
po ang
me, Attorney
proper-
Guevara,
At-
let me, do you mean to tell me, Attorney Guevara, that we are only strengthening because of what the ICC is doing?
No, hindi po. Hindi po. Hindi naman po dahil lang doon.
So let me ask
Ito po ay
Attorney,
duty natin.
let me ask Tony Neri and Attorney address there. On the statement I made, what do you think about that?
Agree, Your Honor, kasi ang tingin ng mundo na dyan, ayaw niyang pasukin because the ICC is right. Di ba? Kasi if it's working, you show it, di ba? So otherwise, ang isipin nila ayaw niyang papasukin kasi the ICC is right and the complainants are right, and so I don't see any problem. Ang intindi ko kay Soljen kanina, wala akong nakitang parang sa kanya, if they want to come, they can come, no? But we have no legal duty to cooperate. It's a political decision. Parang nakita ko naman kanina. So legal duty, in-assert na wala yon, but of course, if Malacanang says so, it's a political decision. They can. So, pero I mean, if it's even political, then that is on the issue of image and diplomacy, as mentioned kanina, that becomes very important. Siyempre sa amin, Mr. Chair, we assert na as we mentioned, 7,732. And then Congressman Flores said, 1,000, halos less than 1,000 ang nabanggit eh. Parang, are you really willing? 7,000, so yeah, Mr. Chair, I agree with your point na ipakita natin na mali sila by letting them witness.
So if you agree with me, Attorney Neri, mag-i-stop na yung akusasyon ninyo.
Well, let's see kung ma-prove ng Philippine government na
Magiging kontento na kayo if you agree.
well, if there is real justice in the Philippines, Mr. Chair, magiging kontento, hindi lang kami, we're talking of the families of the victims. Pag may genuine and serious investigation and prosecution, who is there to complain about serious investigation and prosecution? Yes, Mr. Chair.
Your Honor, let me just put this in proper perspective. Yung pong report na merong mga 6,000 o 7,000 na insidente na may namatay, hindi naman po ibig sabihin na lahat noong 6,000 or 7,000 cases na yon ay nangyari na may abuse or merong lapse on the part of our law enforcement agencies. As a matter of fact, doon po sa initial na evaluation ng Internal Affairs Service ng PNP, ang majority po naman dyan na operations by law enforcement agents were regular. At wala naman po silang nakitang pagkukulang on the part of law enforcement agents. Kaya lamang po, meron ding mga several incidents na nakita mismo ng PNP na may pagkukulang. Kaya yun po ang pinaprioritize na mismong PNP nagsabi may pagkukulang tayo dyan. Pero hindi naman po ibig sabihin na yung 6,000 o 7,000 yon ay puro merong abuse of power ang PNP. Sila mismo nakita na po nila yan on an initial investigation na great majority ay tama naman ang operations. Kaya lamang, ganun pa man, kahit ganun ang sabi ng PNP IAS, ang DOJ po at that time had an agreement with the PNP and the NBI na, okay, PNP, kahit na ganyan ang finding nyo na walang sabit yung mga law enforcement agents nyo, ipagpapatuloy pa rin ng DOJ at ng NBI ang pag-verify. In other words, i-double check namin kung yung in-exonerate nyo ay talagang dapat na ma-exonerate. Pero for now, unahin namin ito, matter of priority. Ito yung in-identify nyo na talagang merong problema. So unahin namin ito, pero hindi ibig sabihin na hindi namin babalikan the other thousands of cases where the police officers were exonerated.
May I clarify, Mr. Chair, my statement? Yes,
Attorney Neri.
thank you. Yes, well, 7,732 cases. Sabi ko nga po kanina, edi sana naman may 7,732 investigations. The Honorable Solgen said, well, we just found the other cases did not commit abuse. There was no abuse. The question of the families of the victims, how did the government even know if they did not investigate? From the data itself of the DOJ, only less than 1,000 were investigated. There is no categorical statement on the part of government so far that we have investigated the 7,732. So how do we even know that there was no abuse during the operations? Because in our opinion, Mr. Chair, and from the testimonies of our victims, ang nangyari lang kasi dyan, Mr. Chair, pag kiniklaim na nanlaban, self-defense, tapos na eh. I mean, that's it. So, ang hinihingi ko lang sana at sana ma-inquest man lang yung 7,732 deaths. That is the process being sworn to by the government, not just the DOJ. Then we do it because it's required by the rules. Otherwise, if we don't do inquest, we only investigate less than 1,000 and just say all the others kasi there was no abuse. We don't even have a basis for that, then may problema po
Neri.
tayo, Mr. Chair.
Sorry if I cut you off, no, but I think what would help also is the figures that we were requesting the PNP and the DOJ to submit. Kasi right now, the figures, 7,000, 6,000, we don't really know where it came from, no? And we would prefer siguro that an official number be given by the PNP and the DOJ and what actions have been taken on these numbers that
That is good, Mr.
Para at
Chair.
least may basis tayo. Kasi we're just like, trying to pick figures from wherever. No? But I think that would be best siguro if PNP and DOJ could submit at the soonest possible time the numbers being requested by Representative Bordado. We would like to recognize Congressman Bongalon, who gave up his time earlier.
Thank you, chairpersons. Good afternoon to everyone. May I direct my question, chairpersons, to the Commission on Human Rights? A while ago, we were telling about the numbers given by the PNP and the DOJ. Probably we can ask the Commission on Human Rights, and probably they can shed light as to the actual number of victims of this so-called drug war. May we know the update from the CHR?
Yes, good afternoon, Your Honors. The CHR actually has 3,998 cases filed before the Commission. This is between the period of May 10, 2016 until September 18, 2023. Out of the 3,998 cases, 90% of which were the investigation of the cases were motu proprio, and the less than 10% was due to the filing of complaints by various complainants, Your Honor.
All right. Isn't it that part of your mandate is that to investigate human rights violations, correct?
Yes,
Now,
Your Honor.
may we know what was your comment or position during the time that the our country withdrew to the Rome Statute?
Yes, Your Honor. While, of course, we respect the wisdom of the national government on the matter, we actually issued a statement during the period that this was happening, encouraging the state to cooperate nonetheless to the investigation of the ICC.
All right. In relation to that, chairpersons, may we ask from the PNP if they are aware of this Executive Order number 2? Anyone from the Philippine National Police? Executive number 2. This is that was issued during the previous administration. Well, in the interest of time, chairpersons, this executive number 2 is with regard to the hindering the Philippine National Police from cooperating with our investigation. That is why there are cases before us that remain pending because the PNP uses this EO not to give us reports on their investigations, especially those cases with regard to the drug on war victims? Yes. Mr. Chair, can we ask from the PNP if they are aware of this executive order number 2 that was issued during the previous administration?
General?
Sir, for me personally, I am asking our legal service, sir, from the legal service.
May probably, Mr. Chair, while waiting for the PNP to respond, may I go back to the CHR? May I know from the CHR what did the Commission on Human Rights do during the war on drugs in relation to the reported cases? Was this reported or submitted to the law enforcement agencies for investigations and, of course, for prosecution?
Yes, Your Honor. Actually, from the end of the commission, there are two aspects. I mentioned we have more than 3,900 cases filed before us. We took cognizance, 90% of which motu proprio investigation. Some, we have a resolution finding that appropriate because we're not a prosecutory body, Your Honors. We can only recommend to the concerned government agency the prosecution of these cases. Therefore, if I may, I have the data. For the criminal cases, we have submitted 22 to the trial courts, 34 to the Office of the Ombudsman, to the Prosecutor's Office 22. Also, we have recommended administrative cases to the concerned government agency, to the PNP-EAS, to NAPOLCOM, and also to OMB. Allow me, Your Honor, to manifest that this number is less compared to the 3,900 that we mentioned due to the EO that you mentioned, Your Honor. Because we have to coordinate with our law enforcement agencies. And we have sometimes, as part of our investigation, we have to ask for police reports, for example, Your Honor. And sometimes this EO would be given to us saying that due to the EO, we cannot give you these reports. That is also one of the primary reasons why many of these cases still are pending with the commission. We could not resolve it due to we could not further gather enough information for its resolution, Your Honors. Thank you.
Thank you, Mr. Chair. So the CHR admits and even recognize that this EO was issued, and this is one of the reasons why there's no an update or the cases are not moving with regard to the victims on drug on war. At any rate, Mr. Chair, I would like to ask the Solicitor General with respect to the signing of the Rome Statute. Mr. Chair, is it possible that the Philippines can still rejoin the ICC by signing the Rome Statute?
The possibility, the matter of rejoining the ICC is, of course, a possibility. It's a decision that will have to be done collectively by the Republic if it wishes to rejoin the ICC. However, Your Honor, we need not sign the Rome Statute all over again because we have already signed it. What we need to do is simply to accede to it. The process is called accession, and that is done by repeating the process all over, meaning the President will ratify our joining the ICC, and the Senate will express its concurrence by a 2/3 vote. After that, the instrument of ratification will be deposited with the Secretary General of the United Nations, and thereupon we become a member again of the ICC.
Okay, so a while ago, it was established that as of today, the position of the government is that we have no legal duty to cooperate. Is that correct?
Yes, Your Honor.
Okay, so with that, assuming that we have no legal duty to cooperate, now, can we allow the investigators or the prosecutors to go to our country and conduct their investigation?
As I said earlier, the prosecutor is free to do whatever he wants to do on the matter of investigation.
On that note, Mr. Chair, may we ask the DOJ, the PNP, as well as the Commission on Human Rights, are you going to cooperate with the prosecutors or the investigators? As mentioned, they are free to go to our country and conduct its investigation.
Your Honor, the Commission is more than willing to coordinate if the ICC so deems that they need our cooperation.
Right.
Yes, Your Honor.
May we know also from the other agencies, chairpersons?
DOJ?
I believe, Your Honor, that we have to defer to the orders of our principals. And of course, at this instance, it's the President of the Philippines.
PNP?
PNP.
Your Honor, I have said a while ago that as to the giving support to the investigation being conducted by the International Criminal Court, we are of the humble view that it would be more prudent if the PNP will just submit to the position of the President as head of the Executive Department, to which the PNP is under, and also with the SILG. If we will be required to submit a petition paper, we will do so, sir.
DFA?
Yes, sir.
In that case, Your Honor, we also defer to the decision of the President, and whatever the decision of the President, the Department of Foreign Affairs will support it. Thank you.
If I may, Your Honor.
Yes, please.
Our position, Your Honor, if I may just add to our position that we are an independent, constitutionally created commission for the promotion and protection of human rights. Therefore, we may and we'll be happy to cooperate if the ICC deems fit that they need their assistance from the Commission on Human Rights. Thank you, Your Honor.
Okay, so it's settled that as of today, Mr. Chair, it is only the CHR who is willing to cooperate just in case the investigators or the prosecutors will go to our country and conduct its investigation. Bago ko po makalimutan, Mr. Chair, meron pa po akong pending question with the PNP. It is about the executive order that was issued during the previous administration.
PNP, do you have an answer now?
Yes, if they are aware. And then again, Mr. Chair, because there are reports that they use it as an excuse not to conduct the investigation. And as mentioned by the CHR, it is one of the reasons why we have a small number of cases with regard to the victims of drug-related war.
Please identify yourself before you answer.
Good afternoon, Mr. Chairman. Police Captain Arpon from PNP Legal Service. To answer the question, sir, yes, sir. Does Executive Order number 02, sir, talks about freedom of information, sir? To clarify, sir. Yes, sir.
Yes, that talks about the freedom of information,
Yes,
and there are reports that that was the reason why there are cases that are not moving, and there are cases that are not being investigated due to the issuance of this executive order.
Yes, sir. The Philippine National Police, sir, is aware of that executive order, sir.
Anyway, Mr. Chair, just to expedite, I may just request from the CHR, though the figures that was mentioned ago, as well as a reiteration, Mr. Chair, from the PNP as well as the Department of Justice as regards the victims of these human rights violations and other agencies that are concerning about this matter. Thank you, Mr. Chairperson.
Thank you.
Mr. Chair, just would like to clarify, SG. You said doon sa accession, di ba, na pag nag-rejoin ulit tayo, should be ratified by the President and concurred by the Senate.
Correct, Your Honor.
So why is it when we withdraw? Hindi kailangan yun.
Because as I explained earlier, Your Honor, when the Senate gave its concurrence, it did not impose any condition that its concurrence would also be required if the Republic would withdraw. It could have done so.
But they can question.
Validly.
They can question.
Question.
They can question the withdrawal
In
of the
fact, they
president.
did by filing this petition before the Supreme Court, but the Supreme Court dismissed the petition. That was questioned actually, Your Honor. Pangilinan versus Cayetano.
So therefore, recently, the president mentioned and said that because of the resolution, that he will study the proposal. Sinabi niya yun eh, di ba?
Hindi po accurate, Mr. Chair.
Ano yung sinabi niya?
Ang sinabi po niya na under study, ayun pong possibility of rejoining the ICC. Pero yung on the matter of non-cooperation with the current investigation, ay inulit po niya ang kanyang statement na we cannot cooperate for reasons already explained.
So therefore, kung sinabi niya under study, what would you recommend to the president?
Pag-aaralan ko rin po, Your Honor. Marami pong factors na kailangan nating i-consider sa pagre-rejoin, kaya kung ang presidente po mismo ay sinabi na kailangan ng masusing pag-aaral tungkol dyan, ay lalo na po ako na kailangan mag-aral para dyan.
Thank you, Co-Chair. May we now, you have just one question, ano? Representative Acop? Okay, go ahead.
Thank you, Mr. Chairman. Kanina pa po ako nakikinig sa mga legal positions ng bawat panig eh. But I think I would agree with the Honorable Guevara that the bone of contention of this issue is contained in Article 127, Paragraph 2. May I know, ano po yung definition nyo ng the term commence? Kasi if I read yung statement na pinagtatalunan natin ngayong araw na ito is, the withdrawal shall not affect any cooperation with the court in connection with criminal investigations and proceedings in relation to which the withdrawing state had a duty to cooperate. That's the first condition. Pero hindi po, may second and ang sinabi, which were commenced prior to the date on which the withdrawal became effective. Yun po yung crux of the issue eh. Di po ba? But may I ask, Your Honor, the Solicitor General, what is, I think this statute has also its rules of procedure. In the same manner that we have our rules of criminal and civil procedure. Tama po?
Tama po yan.
Yes.
Your Honor.
Now, the statement speaks of the term commence. So, going to Webster Dictionary, it means to begin or to start. Tama po?
Tama po.
Would you agree, Your Honor?
Tama po.
Oh. But, doon po sa previous statement, it is in connection with criminal investigations.
Tama po.
Now, when would a criminal investigation commence?
Well, depende po yan kung ang pinag-uusapan po natin ay yung sa ating sistema o doon sa sistema ng
Your
ICC.
Honor, I'm speaking of, I'm citing the statement stated in Article 127 of the Rome Statute. It speaks of criminal investigations.
Apo.
And the term commence was used.
Apo.
Now, may I know, when does a criminal investigation internationally or locally start? That's my point, Mr. Secretary.
Yes, Your Honor. If we are going to base it on Article 13, it is when one of the instances would be when the ICC prosecutor motu proprio requests for investigation. Request to commence. Maybe we should take a look at
No.
Article 13.
Article 13 speaks of exercise of jurisdiction. Yes, I agree, Your Honor. Kaya nga po, tinatanong ko kasi nandito po yung issue natin Kanina ko pa pinakikinggan yung mga legal treatises ninyo pero this issue should be resolved. What is the legal definition insofar as international law is concerned sa term not to commence? And insofar as international law is concerned, what do we mean by criminal investigations? And when does a criminal investigation start with international law? Yun po yung issue ngayon
Yes, Your Honor. In the case of the Rome Statute, which created the ICC, the commencement of the investigation would be at the point where the pretrial chamber authorized the ICC prosecutor to commence his investigation. That is exactly what the two judges of the appeals chamber said. In fact, the prosecutor filed a request for the commencement of his investigation. He made that request to the pretrial chamber in March of 2021. So the pretrial chamber authorized the commencement of the investigation in September of 2021.
I heard that from you, Your Honor.
So that is my answer.
I also listened to my good friend, the Honorable Colmenares. And I'm speaking as an investigator, Your Honor. A criminal investigation starts the moment a complainant files a complaint against somebody. Kaya, tama yung sabi po ninyo, Kong Colmenares. Kanya-kanyang interpretasyon ito. Because look at the rules of procedure. Dito po sa rules of procedure ng Rome Statute, wala akong makita na that will state kung kailan nagsisimula yung criminal investigation stated in Article 127. Yun po yung ko. Thank you, Mr. Chair.
Mr. Chair, if I may just clarify doon, Mr. Chair, just to clarify kung short lang,
Okay.
Mr. Chair. Kasi I agree with the Solgen, exercise of jurisdiction is under Article 13 in relation to Article 15. And that's what the Solgen said
In
kanina.
relation to Article 12.
12. But then Article 13 refers to 15. You mentioned that kanina. What does Article 15 say? So the trigger ng exercise of jurisdiction. The prosecutor may initiate investigations proprio moto on the basis of information on crimes within the jurisdiction of the court. It does not say that the prosecutor will ask, but it says initiate. So that is different from preliminary investigation. And that is founded, Mr. Chair, for the lawyers na lang, under the same Article 15 referred to by the Solicitor General, subsection 6, which says, if after preliminary examination referred to in paragraph 1, which is investigation, the prosecutor concludes that information provided does not constitute a reasonable basis for investigation, he shall inform. And on the other hand, he may even also ask. So basically, ang sinasabi ko lang, Mr. Chair, while of course the victims will argue na nung final namin yan, it's a matter under consideration by the ICC. But even granting the argument of the government na it's Article 12 and 13 in relation to 15, then the start of the preliminary examination, which is in 2018, is the start or the commencement of the proceedings. But the government, well, they argue, no, it's not the preliminary examination of the prosecutor. It's when he or she requests for the preliminary investigation. So that's a matter of interpretation now. But for us, Article 15 is very clear. The exercise of jurisdiction is triggered when the prosecutor motu proprio investigates, doesn't even ask for approval, investigates. And that's why we say under the terms of Article 127, it has commenced and therefore the state has to cooperate. Thank you, Mr. Chair, for that.
Thank you, Attorney Neri. Soljan, can I just get back to you later? I'll just recognize first Representative Manuel for his questions.
Thank you to our chairpersons. Bale po, since many questions have already been posed, I would like to manifest first na dismayado po tayo dun sa hindi pagiging handa ng ating ilang mga agencies when it comes to data which are very crucial sa ating discussion. Halimbawa po, Mr. Chair, na ang main din na inaasahan ng DOJ for its data ang Philippine National Police. Ang pinag-uusapan po natin, drug-related killings na ang mayor din na dapat imbestigahan doon ang PNP mismo, Mr. Chair. And nangyari na rin naman at nagkaroon ng maraming mga testimonials and documentation about cover-ups, tapos pagtatanim nga rin ng iba't ibang mga ebidensya. Kaya Mr. Chair, tingin natin hindi natin mapipilit ang ating mga kababayan kung hindi sila agad-agad na makakapagtiwala hanggang ngayon dun sa nabanggit na mga ahensya at maghahanap sila ng ibang mga recourse para makamit talaga yung hustisya. And Mr. Chair, naunawaan ko rin kung bakit tinuturing na controversial ang issue na ito kasi maliban sa dating Pangulo, napangalanan din sa mga dokumento ng ICC ang nakaupong Vice Presidente tsaka 2 senador. Gayunpaman, Mr. Chair, kapag gumulong na ang lahat ng kinakailangang proseso sa bandang huli, walang sino mang tao ang dapat na makawala ng hindi nananagot kapag may nagawa silang kasalanan sa bayan. Kahit dating mataas na opisyal pa yan o kasalukuyang nakaupo sa pwesto, kahit dating presidente o dating PNP chief pa yan. Hindi rin dapat ginagamit ang anumang posisyon sa gobyerno para protektahan ang sarili o ang kamag-anak na dapat humarap sa investigasyon. Kaugnay po niyan, hindi dapat gamitin ng sino mang opisyal ang kanyang posisyon sa gobyerno para din atakihin ang mga kabataan at kababayang nagsusulong ng hustisya at pumapanig sa mga biktima ng war on drugs. Kaya kung meron pong investigasyon na dapat matuloy at mabilis na umusad, ito ang investigasyon sa lahat ng mga nagpasimuno ng madugong giyera kontra droga. Hindi forever ang impunity at kasaysayan po ang nagpapatunay na maniningil talaga ang mga naapi. Kaya dapat din maghanda ang mga sangkot dahil ang mga ebidensya laban sa kanila ay sobrang bigat na. Hindi gawa-gawa, hindi pinwersa, kundi sapat na batayan para seryosohin ang pagtiyak ng pagpapanagot sa mga may sala. Yun na lang po to our chairpersons. Thank you very much.
Thank you, Representative Manuel. Representative Franz Castro.
Thank you, Mr. Chair. So hindi na rin ako magtatanong usapang legal yung mga usapan dyan. Pero regardless, although mahalaga po yung katulad ng sinasabi ninyo na jurisdiction, yung kung ano-ano man dyan. Pero ang primary po dito, Mr. Chair, 7,732 ang namatay. Saan ngayon pupwesto ang mga ahensya ng ating gobyerno? Dismayado ako no? Doon sa sinasabi ng ating mga resource person dito aside from kay Attorney Neri and the rest. Yung mga agency, dismayado ako except for CHR for cooperation. Alam niyo po ang primary dito, Mr. Chair, pinag-uusapan dito ay buhay. So wala pong mga impediment dapat na napipigil doon sa paghahanap ng hustisya para dito sa 7,732. Actually, marami pa to kung tutuusin natin. Ito nga lang yung reported. Wala sa kasaysayan natin ng administrasyon na may namatay na ganito karami. So titignan na lang natin sa war on drugs. At alam natin nangyari itong mga patayan na ito dahil sa kagagawan o sa policy ng government nung nakaraan. Ito yung war on drugs. At ang ginamit na pamamaraan dito ay tukhang. At ito yung mga nangyari. Kung makikita ninyo, kung nagbabasa kayo ng mga istorya ng mga biktima, maiiyak po kayo Pare-parehas ang pattern, nanlaban, naglagay nagplanta ng mga ebidensya. So ito ba ay hindi concern ng gobyerno sa ngayon, Mr. Chairs? Dahil well, talagang ano no, kung concern talaga ang gobyerno at seryoso talaga sila, lalong-lalo na ang DOJ, ang PNP, o hindi, di bali ng PNP sangkot sila no? Sa genuine prosecution na sinasabi po doon sa Rome Statute, ay dapat ay hindi lang 50, hindi lang 57. Kung naging meron mang uninterested o na mga biktima po o mga pamilya ng biktima, so dapat tinulungan po natin sila, no? May mga moto proprio tayo na pwedeng gamitin. So in the span of 6-7 years, ganito lang yung nagawa ng ating prosecution. No wonder bakit tayo ang sama ng image natin sa international, ang pumapasok ang ICC dito dahil 7,000 is 7,000. Isa nga lang yung mamatay, concern na talaga, Mr. Chair. Kaya tayo, so kami, resolve kami talaga na payagan natin yung ating yung ICC na mag-cooperate. So in-encourage ko talaga kasi sinasabi ng mga resource person natin dito na National Government Agency, it's up for the President. So kami, nag-aapela talaga kami kay Presidente na payagan yung pag-ano dito, no? Napayagan at mag-cooperate sa ICC dahil inutil yung ating inutil dahil 7,000, 50 lang, inutil yung ating mga ahensya.
Thank you, Representative Castro. Now we're going back to Representative Lagman.
Actually, Joint Chairman, the exercise of jurisdiction, which is the second aspect mentioned by the Solicitor General, is covered by Article 13. And that exercise of jurisdiction commences when the prosecutor has initiated an investigation in respect of such a crime in accordance with Article 15. That is when that jurisdiction, when the exercise of that jurisdiction commences, because the prosecutors are part of the ICC. Now, what does Section 15 say? Section 15 provides for two kinds of investigation. One is investigation motu proprio of the prosecutor. But under the agencies, under the coverage of the ICC. And the second investigation is the investigation, which is usually referred to as the preliminary investigation, as authorized by the pre-trial chamber. But that second investigation is not the commencement. The commencement is the investigation motu proprio by the prosecutor. What is the language? It says here, if the prosecutor concludes that there is a reasonable basis to proceed. The word is proceed. That means to say, nagsimula na, ipagpapatuloy lamang. That's why we should not base our government's objection to the preliminary investigation by saying that it came after the effectivity of our withdrawal, because the investigation commenced prior to the effectivity of our withdrawal from the ICC. I think that should be impressed on us. Now, with respect to the sovereignty of the state, sovereignty, Solicitor General, is that absolute? Is that correct?
Hindi ko po nakuha yung tanong.
Sovereignty is not absolute.
Yes, it is not absolute.
Is it not absolute? Because there are times when the state would voluntarily, quote unquote, surrender a portion of its sovereignty, as when it becomes a state signatory to international conventions like the Rome Statute. Is that correct?
Tama po yan.
Tama yun. Now, let us go to the import of the obiter dictum in the case of Pangilinan versus Cayetano. Obiter dictum is not a useless surplusage.
It is not.
It is not. It expresses the sense of the court as guidance. Is that correct?
Tama po.
Okay. So let us not demean that decision that there was an obiter, because that obiter is significant. And my last question, our good solicitor, is if the House and the Senate would approve their respective resolutions urging the government to cooperate with the ICC, what would be your recommendation to the President, who has the onus of making that final decision?
You're asking for my recommendation? Your Honor, if it were just probably some members expressing their sentiment, I would not have any problem with that, Your Honor. But if it's an institutional resolution, meaning as adopted, and it's the House itself and the Senate itself expressing that sentiment, it will really be a very complicated situation, Your Honor, because from the point of view, from an external point of view, it would seem that the Republic is fragmented in its position. One political department is saying something, and another political department is saying another thing. When the President made his statement that that the government will not cooperate, my understanding is he was saying that as head of the Republic, as head of the state, the sovereign Republic of the Philippines. He was not saying that simply as chief executive or as the head of the executive department. He's saying that as the head of state. And therefore, Your Honor, that will put him in a very difficult situation. I cannot, as of this time, think of a recommendation to give to him. It's really something that I would request Congress itself to think about, because as I said, it will appear to the outside world that the Republic is fragmented.
Well, if the Republic is fragmented, there is good reason to unite the political departments. And nothing is cast in stone. Do you agree?
That is true.
And the president can change his mind and consider the joint sentiment of the House and the Senate. Is that possible?
I am sure, Your Honor, that if the proposed resolutions come to pass and they are adopted as institutional positions of both the House and the Senate, the President will definitely consider your resolutions.
Mhm.
But whether or not he will actually follow your request that we cooperate is something that he alone,
Mm.
as head of the government, head of state, and representative of the republic, may decide on.
But you know, the president does not act alone. That is why he has his cabinet. He has his Solicitor General. Is the Solicitor General ready to defy the resolutions of the House and the Senate?
Your Honor, the resolution is not addressed to me. It's addressed to the president. And
It's addressed to the executive department, to the government, and you are part of the cabinet of the president.
yes, Your Honor, but since the president is the chief executive and he is the person or officer principally in charge of foreign relations, then his own decision on the matter will be most crucial.
Okay.
Of course, this will be studied by members of his cabinet, his legal advisor, his political advisor, and so forth and so on. But I think since he is the primary architect of our foreign policy, under which the matter of this ICC investigation falls, then I guess we should all give some respect to his decision on the matter.
Well, we give respect, but we would like also to put out our own sentiment on the matter. Suppose the president would ask you, Mr. Solicitor General, what is your recommendation after the Senate and the House approve the resolutions?
Your Honor, I have already taken a position on this matter when I represented the Republic of the Philippines before the ICC Appeals Chamber. And I have no reason, Your Honor, to change my position. So if the president would ask me about my personal position on the issue, I will stick to what I have always adopted before the ICC.
And in that appeal before the ICC, the government lost because the ICC said that the preliminary investigation must proceed.
Your Honor, lost, yes, in that sense that the prosecutor was authorized to continue with this investigation. But to a certain extent, that decision was also a failure. And why so? Because it did not rule on jurisdiction. And that is why I'm saying, Your Honor, that although we have different interpretations as to the meaning of Article 13 in relation to Article 15, the time will come when this issue will actually be raised again before the ICC. And when will that time be? When specific concrete cases are filed against certain specific individuals are concerned. And these individuals will raise the very same issues raised by the state. So that will be an opportunity for the ICC to do what it failed to do when we filed our appeal before the ICC Appeals Chamber.
In other words, Mr. Solicitor General, you will tell the president that you are maintaining your appeal, the issues on which you raised on appeal before the ICC, and consequently, impliedly, you are saying, don't don't follow the resolutions of the Senate and of the House.
Your Honor, I respect the resolution of the House if it will be adopted. If a similar resolution is adopted by the Senate, I will also have to respect that. But if you are asking for my position as Solicitor General, I cannot depart from a position that I have consistently adopted.
But we should remember that the bottom line of that appeal is the Republic lost its case. Although the ICC did not rule categorically on jurisdiction, because the majority decided that jurisdiction is obvious. It's obvious. If you read the Rome Statute, it's obvious that it has jurisdiction. Most probably it was just trying to save the Republic from further embarrassment. Thank you, Joint Chair.
SG, mukhang nagbago yata yung timpla ng sagot mo. Because I asked the same question to you. Sabi mo sa akin, pagkaaralan mo pa eh.
Well, this is the opportunity to say it, Your Honor. Since I was pressed for an answer, I had to give it, and I have no reason to depart from what I had already stated. I think it's not only improper, it's illogical.
But nothing is cast in stone.
Ang bilis.
No, Your Honor, I'm talking from a legal standpoint. I'm not speaking as a political person.
Even in legal parlance or jurisprudence, nothing is cast in stone, because the Supreme Court would even depart or reverse its previous decisions.
That may be true, Your Honor. That's why I'm saying that the bone of contention here remains unsettled, and there will be future instances where this issue of jurisdiction and exercise of jurisdiction will actually be the subject matter. And that will happen probably when Article 19 on specific concrete cases actually arise.
Well, with all of the legal questions and answers, my co-chair and my colleagues, perhaps knowing that the president is also a politician, that if Congress and the Senate adopted this resolution, it means that it represents the whole country and the electorate of the whole country. Perhaps he might be able to change his mind. And because of that also, Mr. Chair, our good Solicitor General will also change his mind later on.
Thank you, Co-Chair. Last, who wants to
Yes.
be recognized? Representative Arlene Brosas.
Yes, Mr. Chair, thank you. Last manifestation lang, Mr. Chair. Mr. Chair, interestingly, no, ang history natin, during the ratification of the Rome Statute sa Senate, one of the senators who said yes to ratifying ICC inclusion is our current president. No? So, Mr. Chair, as one of the 48 states who voted in favor of the adoption of the Universal Declaration of Human Rights, the Philippines has recognized that everyone has the right to life, liberty, and security, and that everyone has the right to a fair and public trial. This recognition became part of the law of our land through its incorporation in our Constitution, Section 1 of Article 3 under the Bill of Rights. No person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. However, during the war on drugs of ex-President Duterte, from the time he was mayor of Davao to when he became president of the Philippines, around tens of thousands of lives have been lost due to the extrajudicial killings or to just being in the wrong place at the wrong time. Not one of them were given the opportunity to exercise their rights under the supreme and fundamental law of our land. Until now, justice for these individuals have not been given. The authorities responsible for their demise have not been successfully prosecuted, while those responsible for these deaths roam free. The surviving loved ones feel the brunt of their loss every single day. It is the state's responsibility to ensure that it upholds our Constitution. While the deaths of thousands of people during ex-President Duterte's war on drugs can never be undone, the fight to seek justice for these slain people still remain. From 2011 to March 2019, the Philippines was still part of the Rome Statute of the International Criminal Court, and any and all acts done during this period is under the ICC's jurisdiction. In a 2021 decision, no less than the highest tribunal of our country, the Supreme Court recognized the Philippines' commitment to meet its obligation under the Rome Statute. The withdrawal of the Philippines from the Rome Statute does not remove ICC's jurisdiction over the actions done by the Philippines prior to such withdrawal. Until now, there have been no genuine prosecution of state agents or officials who are responsible for the extrajudicial killings in ex-President Duterte's war on drugs. The Philippine justice system has not been working for these tokhang victims. It has not been working for them from the start of police operations. The ICC Office of the Prosecutor has already found sufficient reason to start an investigation to find justice for these victims who were not able to find immediate redress in their own justice system. It is only fitting that the Philippines, as a show of solidarity and respect for the right to life as enshrined in our Constitution, to cooperate with the ICC in order to bring justice to those who were unfairly killed before they even had an opportunity to defend themselves in the proper court of law. We in Gabriela Women's Party wish to reiterate our stance to urge the Philippines to cooperate with the ICC's investigation on possible crimes against humanity committed during the administration of former President Duterte, both as the mayor of Davao and the President of the Philippines. Thank you very much, Mr. Chair.
Thank you, Representative Arlene Brosas. Any other member who would like to have to ask questions on our resource persons? No more? Chair.
Well, if there's none, then
Representative Bongalan.
Thank you, Mr. Chair. Mr. Chair, on the part of the Committee on Justice, I move to adopt House Resolution number 1477 without amendment in consolidation with House Resolution numbers 1393 and 1482. And I also move for the approval of the corresponding committee report. I so move, Mr. Chairman.
Mr. Joint Chairs, on the part of the Committee on Justice, Committee on Human Rights, I move to adopt House Resolution number 1477 without amendment in consolidation with House Resolution numbers 1393 and 1482. And I also move for the approval of the corresponding committee report. I so move, Joint Chairs.
Second, Mr. Chair.
There's a motion to adopt House Resolution number 1477 in consolidation with House Resolution number 1393 and 1482. Duly seconded. Is there any objection? There being none, on the part of the Committee on Justice, House Resolution number 1477 is adopted without amendment in consolidation with House Resolutions number 1393 and 1482. And the corresponding committee report is hereby approved.
on the part on human rights, the same thing is approved.
Other matters?
Mr. Chair, considering the filing by Senator Ontiveros of a similar resolution in the Senate, I will respectfully request the joint chairs to coordinate with Senator Ontiveros so that we could transform our respective resolutions to a concurrent resolution.
Is that a motion?
It is a motion.
Is there any second?
Second, Mr.
Okay,
Chair.
it's been moved and seconded that the motion of Congressman Lagman be approved. So if I approve.
Are there any other matters?
Mr. Chair, may I respectfully move that we adjourn the joint session on the part of the Committee on Human Rights.
Ken,
I move to adjourn the committee meeting on the part of the Committee on Justice.
The meeting is adjourned. Thank you everyone for coming.